I was just noticing that the case was noted for a temporary order, and my understanding from our last hearing was that the parties would need to renote that separately for the temporary orders, that we were just here for the GAL review today. So I just wanted to confirm what we would be addressing.
Okay. Ms. Turnbull, do you have any input on the scope of today's motion or hearing?
I don't see that anything was filed, so I am not very clear about the scope of today's meeting.
Okay, that's a fair answer. Let me ask Ms. Carranza as far as items to be addressed in today's hearing.
I've been trying to get a hold of Ms. Turnbull in regards to visitation and whatnot, and just trying to get everything situated. And I have yet to be able. I've contacted her once, been in contact with her once, and it was right after court last time.
Okay.
But have yet to be able to get back in touch with her. I'm in between phones. I've also had a few other things come up aside from this case in regards to my other daughter, who I'm going through dependency for. That's what the documents that I'm trying to get in order to turn into you guys, because I do have visitation with my youngest with a visitation specialist. I myself am unable to pay for that out of pocket. And still have not had any visitation or contact with the kids, as I'm still unsure of the no contact order, or I'm not sure how if it's a no contact order or restraining order, and what I'm allowed to do and not allowed to do. I know it says not to disturb the peace. However, sending a message could just be disturbing their peace, and that's not at all my intention. My intention is solely my kids. If we have to have a third party to communicate, I'd be more than willing to do that. If it's, disturbing the peace just to make contact with their dad to try and set up a visit or just video chat with the kids. I'm going on since April without seeing Labea. Beth and Anna I haven't seen since January, February. So as long as I've been without my kids, I was just approved for drug court. And so I've got a whole other things going on. My kids are my main priority, but drug court kind of tops that, because if I don't do my drug court and stay in compliance with that, then I get taken from my kids altogether. And I'm not trying to do that. So working with CPS and drug court, I'm doing everything I'm supposed to be doing. I have SUD assessment today at 2 o'clock at Fort Maine. I attend NA meetings. I'm working the steps. I'm doing everything I'm supposed to be doing. I'm just, communication is hard because I'm in between phones. I just got an actual working number, so I do plan on reaching out to Ms. Turnbull later this afternoon, if not tomorrow. So my apologies for not getting the documents that I asked for this to be sent over, turned in. I'm trying to juggle a lot here, and one person is a little difficult.
Okay. All right, thanks for that update. I appreciate that. And then, Mr. Ruby, just your impression of what the scope of today's hearing was going to cover.
I was just hoping that we were just going to end it all today, get everything figured out, and just get everything finally situated.
Okay. All right. So I appreciate everybody's input. Kind of what I gathered from the review of the file yesterday was that there was an order entered in on April 17th that gave custody of the children to Mr. Ruby, and then Ms. Carranza was going to have, the order said that she could have a professionally supervised visitation 2 times a week for up to 2 hours. And then Mr. Ruby's child support obligation was terminated because he has custody of the children at this point. And then the last part of that order is that Ms. Turnbull is going to provide a report by May 29th. So I think that report has been submitted. It was that submitted on June 28th, Ms. Turnbull, thereabouts?
Yes, thereabouts, yes.
Okay, all right. So as far as today's hearing, I think that order from April 17th is still in effect. So I'm not sure if what else we would be doing here today, because it sounds like Ms. Carranza was going to get some additional information. She has a lot going on with dependency cases and the drug court and the like, and so she doesn't have that at this point. So I'm not sure if there's anything really to do. There's not a pending motion, so I'm inclined just to say we have that order in place, and the children are with Mr. Ruby. There's potential for visitations, and Ms. Carranza is working her steps, hopefully getting stronger and better, and so the children, stronger, better parents are always better for the children. So we definitely encourage everybody's effort in that regard.
Is there a way to, my bad, can I ask, am I allowed to video chat with the kids? Like, I don't, so I've been told that I'm allowed to, I've been told I'm not allowed to, and I just would like clarification on that, because I don't want to reach out to anybody and get myself in more trouble than I've already gotten myself in.
Sure. You said that there was a restraining order. I'm not sure where that order is coming from. Is it a criminal matter
Well,
or civil?
so at the very beginning of this case, 2
Okay.
years ago, there was a restraining order. I wasn't allowed any contact with Marcus at all. And so my understanding is that original order was put back into place. And so that's where my confusion is coming into play. And that's why I haven't made any contact, because I don't want to get in trouble.
Yeah. So let's see if I can find that here just quickly. So February 13, 2024, there's a temporary restraining order that was entered that restrained Ms. Granza Carranza from disturbing the peace, as you'd mentioned, of the protected person or any of the children, Bethany and Anna. That was a temporary order. Then that order was reissued on February 28th. And it was set over to March 13th to review that. And then on March 15th, that was extended again until April 3rd. So on April 3rd, it was reissued, and we set the matter over to the 17th of April. So from there, I see that the temporary order was, had been extended a few times. We get to April 17th, and then I don't see an extension at that point, unless I'm missing something. April 17th, let me go back. Did I miss one?
That's my understanding too, Your Honor, is it kind of got dropped from there.
So I think at this point that the restraining order is not in existence.
Okay, I just don't, sorry, excuse me. Like I said, I just want a clarification, because I don't want to reach out and get myself in any more trouble than I've already gotten myself in.
Right. So at this point, the April 17th order controls talking about primary custody with Mr. Ruby. There's not a provision therein regarding video visits and the like. If the parties can agree to that, that's fantastic. If you can't agree, then one party could bring a motion and ask the court for that particular relief.
Okay.
So at this point, I don't think there's anything to do today other than that clarification we just made. So we'll just strike the hearing, and then the parties, if there's any future relief that you're asking for, we'll continue. We'll hear from you, but at this point, we'll just work under the April 17th order.
Okay.
Okay. Any questions?
For the visitation part of it, my thing is she was set to do those a while ago and has yet to do any of that, and it's all she has to do is just go to the CPS case to do it, and she hasn't. Because we've been in contact with Rachel, the head of the CPS office there, and that's all she said she had to do is just go and set the visits form
Your Honor.
for the
Well,
supervised visits.
Yeah, I'll let the parties figure out the visitation. The order is going to control, and then hopefully that visitation time can be figured out. But at this point, we'll just let the parties work on that.
Yeah.
Just to,
So I don't think there's anything else to do today. So there's no pending motion. We have a lot of cases on today. So if you have one final question, I'd be happy to entertain that. But I think that
just in regards to the getting in contact with CPS, I work with CPS on a daily.
Okay.
And that like I've asked my worker who's handling my dependency case in regards to it, because there is no active CPS case with with Bethany, Anna, and Livea.
Okay.
They can't do anything about supervised visits over there.
Okay. So at this point, I think that my earlier comment stands. Nothing for me to decide today. So appreciate you being here today, and good luck with this. Wilson and Robert Wilson, come on up. Feel free to take a seat at either one of the council tables. It doesn't matter. Just make sure you're positioned in front of the microphone. It does not amplify your voice, but it does capture for the recording purposes. So Mr. Wilson is here in the courtroom, and then I'll ask if Amanda Wilson, if you're on the Zoom call. Amanda Wilson, if you are, please state your name and let me know you're here. So I'll do a quick little search under her name to see if she's on the Zoom call. So this is a motion related to child support. So I saw that there's a service provided by Ms. Looney of their proposed orders of what she thought the child support matter should be. And then she provided proposed orders related to that. And then I see that there's a joint submission, it looks like, with Mr. Wilson and Ms. Wilson, indicating what you're setting your incomes at and what the child support should be. And then also there were some agreed orders, it looks like, signed between both Mr. Wilson and Ms. Wilson related to a findings of fact, a final dissolution decree, and then a final parenting plan. So that's kind of where we're at. What it's docketed for today has been docketed by Ms. Looney for her motion related to child support. So, Mr. Wilson.
Yes. Amanda, she couldn't be here today. She wanted to be, but she had a previous engagement she was unable to get out of. So as far as like the child support goes, I believe in the paperwork it says that we wanted like there wouldn't, since we're going to have equal custody, like 50-50 split, that there wouldn't be a child support. The thing that the state stepped in was because of there was TANF involved.
Mm-hmm.
She took some TANF money, I think that's what it's called, and I think that's why we would have to pay it back. But I believe the paperwork says that we would do 50-50 custody, and she wasn't looking for child support.
Okay, so that's one question I had with the paperwork that was submitted regarding the parenting plan. Let me just pull it up in here, and I can speak more to the point on it. So in the parenting plan, I was looking at it last night, and it was a little bit confusing to me. And I'll just point out that my areas of confusion, because it may not be confusing to Mr. Wilson, but to me it was. So on page 7, it shows the custodian is Amanda Wilson. Then it talks about a school schedule on page, on the paragraph 8. And then it goes on to say that this will start immediately. The children are scheduled to live with Amanda Wilson, except when they're scheduled to live with Robert Wilson. And then it doesn't give any specifics, doesn't give any guidelines, doesn't give any dates, doesn't give any times. It says the parties agree that it's in the best interest of the minor child that the parties share parental responsibilities. Each party recognizes that the other has a right to and shall fully participate in all important matters pertaining to the minor child's upbringing, including health, welfare, and education. The parties agree that they shall have shared legal custody of the minor child and that all decisions regarding health, medical, dental care, education, religion, vacations, travel, welfare, and other aspects of the upbringing of the minor child shall be made on a joint decision-making basis. And it says that the school schedule shall be the same. And so what that tells me, not a lot. So it doesn't tell me that that's a 50-50. What that tells me, it sounds like a fairly cooperative arrangement, but it doesn't tell me that it's a 50-50 plan or it's a primary custody to one parent and alternating weekends on another. So that's why to me, it's vague. It's vague. And so maybe what we could do, we could hear from Ms. Looney to hear what her perspective is related to the child support and also that proposed parenting plan. And then we can hear from you, obviously. Ms. Looney.
Thank you, Your Honor. So Mr. Wilson is correct. The state is involved because the child is currently receiving TANF benefits. We did file our motion because there was some confusion on our part as well, based on the parenting plan, as well as the proposed child support order that the parents had filed. There was conflicting information in their proposed child support order as well. For our part, it sounds like the parents are agreeing that the mother will be the custodial parent, regardless of whether there's a 50-50 residential time. There would still be the requirement to pay child support so long as the child is on TANF. So the state's request regarding child support would not change if there was a 50-50 plan. So at this time, we would be requesting that our order be entered as we presented it. We did use Mr. Wilson's quarter 1 of 2024 income from employment security to calculate his income. We came up with a gross monthly income of $64.27 and a net of $53.11. For Ms. Wilson, we did use her previous income for quarter 1 of 2024. Even though she is currently on TANF, she has shown consistently that she does earn above minimum wage. We did have her average wage at $23.07, and we did impute that at 35 hours per week. That gave a gross monthly income of $35.07 and a net of $30.44. The resulting transfer payment based on those incomes is $832 from Mr. Wilson to Ms. Wilson. We are requesting that that begin May of 2024. That is the first month the child began receiving TANF.
Okay.
Oh, additionally, Your Honor, we did leave in section 19 in its entirety regarding the tax exemption. If the parents did want to address that, the state takes no position as to which parent claims the child for tax purposes.
Okay. All right. Thank you. And then Ms. Looney, with regard, maybe you could just provide a little more detail of your position related to the parenting plan, where you indicated that even if, a couple has a 50-50 plan, the state still has an interest. Can you just kind of explain the rationale behind that?
Yeah, sure. So when the child's receiving TANF benefits, the parent who receives support subrogates their right to collect to the state of Washington. In addition, under RCW 2619.075, subsection D, it is required that residential credit cannot be applied as long as the child is receiving TANF benefits. So even if the parents did agree to a 50-50, so long as the child is on TANF, there could not be a residential credit applied to deviate from the standard calculation of $832.
And when you talk about residential credit, that's a credit that's given for when a parent has more time with the child.
Yes, Your Honor.
Okay. All right. Thank you. Okay. Mr. Wilson, what other information would you like me to consider?
I thought she was on TANF, but now she is not. Would that have a bearing on that?
It may. The representation of Ms. Looney says that she was current, and you're indicating that she's not currently on TANF, correct?
Your Honor,
That's-
as of yesterday, her TANF was still active.
Okay.
Okay. All right. Other questions or points to be made?
No.
Okay. Let me just check. I need to look for one other document that were submitted here. I believe these were submitted by Ms. Looney, so let me pull those up. And Mr. Wilson, did you receive a copy of these proposed orders from Ms. Looney? It has a
Yeah, I believe that's what this is.
Okay, so one on the cover sheet on the top right side, it says worksheets, computation of child support obligation. Another has a title of child support order. Another, yeah, so those are the documents that I was looking at. And then I see your proposed child support order where you indicated that your net income was 3127 and Ms. Wilson's was an income of a net of 2619 per month. Are those accurate figures?
Yeah, I believe, yeah, they are for the most part. I don't know what she works or gets right now. I mean, but I think she's been working 3 days a week versus she used to work 4.
On the same page. I'm not going to be part of the selection.
Let's see. Just need to track down that stray person that's speaking in the microphone. Apologize.
Sure.
Julie. Okay. Great, thank you. All right. So with regard to the state's motion related to child support, that's based on the state is paying TANF monies, and per Ms. Looney, that's still active as of yesterday. So the state used employment security data information, which shows earnings on a quarterly basis that's reported to them. They collect that. And so looking at those figures, that it seems to capture fairly accurately Mr. Wilson's gross and net incomes based on those figures that were provided in that employment security data information. So that's at a 5311. So I think that's a fair setting of that net income. So I'll set Mr. Wilson's income at that 5,311 per month. As far as Ms. Wilson, she's not here today. She did receive notice of the hearing, and there's been some submissions related to other matters that she's submitted and signed. So as far as her, it's imputed. And I'll accept that level at the 3,044 net imputed as to Ms. Wilson. And so I am going to order that the child support start on. The request from the state is that it starts in May sometime. Mr. Wilson, do you have any comment on when the start date should be?
I guess my question is, that'll be back pay.
Yeah, right. If there was an order that said on May, then there'd be a May obligation, there'd be a June obligation, then a July, and so forth.
How would that break? Would that just be like partial payments or all due at once?
That's a good question. Ms. Looney, do you have any input on that?
Your Honor, BCS would work with him to set an amount that would come out of his earnings for the back support. It's typically not the full amount all at once. But if Mr. Wilson wants to make specific arrangements to pay all at once or in small amounts, he can do that with the support enforcement officer.
Okay. Does that help?
Yeah, I guess.
As far as information.
I guess I'd have questions, and I don't know if this would be your area, but I've been helping her with bills and stuff for the last, I've been paying like the mortgage, like power, water, sewer, garbage, and all that. But I don't know if I could say, hey, I've been paying towards that more than $800 that it would be like $1,200 to $1,300 paying towards helping with the bills and some other things, you know. If I could show that, could that be kind of since wipe out that, or is that totally separate?
Not necessarily. The court is charged with making equitable decisions in family law cases, and so there's not necessarily strict guidelines in all areas. And so the states here is requesting that the payments begin in May. I'll have the payment begin on July 1. So the obligation would commence on July 1 of 2024. So this month. So it'd be July and then moving forward for that obligation. So I've signed off on those on the child support order that was presented by Ms. Looney and also the corresponding worksheets. Mr. Wilson, if you need copies of those, certainly you can check with the clerk's office and get a copy of those so you know exactly what they say. Then the next part I just wanted to address briefly. This relates to the agreed orders that have been signed by Mr. Wilson and Ms. Wilson. I looked over those. As far as the findings of fact and conclusions of law, I don't necessarily have an issue with that. I'm fine with that. However, the final dissolution decree, when I looked at that, there were some concerns in there that I had as far as there's some confusion in particular related to the home, to the real property. So it states in here, okay, so that it shows that the 250 or home would be given to respondent, and then the next line says that it'd be given to petitioner. My sense is that it would be split.
Yeah.
That would be sold at some point and the proceeds divided.
Yeah. So when we filled that out, her and I were in agreement that I would stay there, but have to sell it within like 2 years or something, you know, and then or pay her the difference of like what the equity value would be as a split.
Gotcha.
Currently she's still living there, but the agreement's still essentially the same. It's like 50-50 split. Still plan on selling it within the 2 years and or equity split. It's just I won't be living there versus what I think that's what it says. It's like I'll be living there. And she initially had plans to leave the house, but things changed.
Sure.
It's fine by me, you know.
Yeah. So that's my one issue with the final dissolution decree. I can't order that both parties get the house. So there has to be some adjustments to that order. In that it may just be simple language that the parties anticipate, you know, that the house will be sold and the proceeds will be divided. But the way it's presented right now, it gives you each 100% interest in that real property, which isn't necessarily the case.
So it'd have to be like 50% interest, essentially.
Essentially,
just
right.
The little change in that one word.
Yeah. Yeah, and I mean, I didn't look at it with a super close eye, but that was the one thing that jumped out at me. That would cause an issue, and I think it would prevent me from signing off on that because it's unclear, and I think it's not a. I can't give you both 100%, and it's like a 200% interest that's being given, but there's only 100% interest present. So then also with the final parenting plan that's been submitted by both of you, you both signed off on that. The one issue I'm not sure on this. I guess, you know, overall it sounds like it's a very workable, pretty open-ended parenting plan, which for some people that works great. And if it looks like you both are comfortable with that, then you've both signed off on that. So I don't have any reason to not sign off on that. So at least with the parenting plan, I can sign off on that as that's been agreed between the parties. But the findings of fact, as a general rule, I think that's okay, except for the potential connection to the real property. Although it does list the property, the Colorado Street address as community property. So that's positive. Let me just look over here. There's a division of liabilities. No spousal support, no protection order requested, no pregnancy. List your one child, Jonah. It mentions child support. It mentions parenting plan. So I think as far as the findings, I need to hold off on signing on those until the final dissolution decree is adjusted. And the final dissolution decree, that's the one that talks about the percentage interest in the home. Okay. So what I'll do, I'll sign off on the parenting plan at this point. So that piece is completed. However, the dissolution and the final, the findings and conclusions, those would need to be, well, the dissolution have to be amended, then the findings could be resubmitted. So what I'll do, I will give these documents back to you for your records so you have them. And then you can use that as a draft or make any additions that you need to. So today what's been accomplished is the child support order has been fixed, and then the parenting plan is in place. And then the dissolution and findings are the ones that just need to be redone, and those could be submitted ex parte, meaning you don't necessarily need to set it for a hearing, but it could be sent to the clerk's office and say, hey, these have both been agreed and signed off on. And then it could be reviewed by a judge and then signed if agreeable to the court. Okay. All right. Any
Your Honor,
Yes, Ms. Looney.
yes, sorry. Before we conclude, if I could just ask, Your Honor, to go to page 5 of the child support order on section 19. If Your Honor could just draw a line through the checkboxes for every year alternating and other in that section, since we don't have both parties today to set an order regarding a specific order regarding taxes. It would just then say that the parties would need to follow IRS rules and cooperate to fill out the form 8332 for the years when the non-custodial parent would be able to claim the child on taxes.
So you're looking at paragraph 19, it says tax issues. So you want the
Yes.
language that says the parties will follow the law and the IRS rules about claiming children on tax forms, and then add language related to a form 8332.
That is actually included underneath. We could just cross out that the parties have the right to claim the child, and then those 3 separate sections with the empty checkboxes, because we're not making an order regarding who's claiming the children when or the child when. Just for clarity, for enforcement, I think that would be prudent to just eliminate those so it doesn't look like that piece was neglected to be completed.
Okay. All right. So Mr. Wilson, what she's talking about is on this child support order that she presented. This is on page 5 of 9 on the state's order. So Ms. Looney suggests just keeping the first paragraph and the last paragraph under section 19. So it's not the table, it's the one that just says child support order on the front. And then you look at page 5, section 19.
Seen it in the ones you gave me, or just the other one?
The one that Ms. Looney provided to you. And it's on the front, in the right middle, it says child support order.
The tax issues?
Yeah, tax issues on section 19. So there's the box, that box language would stay there. Then Ms. Looney proposes keeping the next paragraph that says the parties will follow the law and IRS rules about claiming children on tax forms. And then she wants to keep the very last paragraph under that, or in that section 19, that says for tax years when a non-custodial parent has the right to claim the children, the parents must cooperate to fill out and submit IRS form 8332 in a timely manner. She's proposing that everything in the middle between those 2 paragraphs be omitted at this point in time. So, and I'm fine with that. Do you have any concerns with that? Okay. All right. So I've omitted that middle language, and then I've left the remainder as is.
Thank you, Your Honor.
Any final items, Ms. Looney or Mr. Wilson?
Nothing from the state, Your Honor.
Okay. All right. Well, thanks everybody for your input and help. I appreciate that. Summer
that'll
Norris is on the
conclude the
line. Summer
today.
Norris.
Thank you,
Yes,
Your
I
Honor.
am.
And I will just
Okay. Welcome to you, Ms. Norris. And Ms. Norris, if you have your camera, if you could turn that on, please, that'd be appreciated. And then Bradley Evans, are you on the line? Bradley Evans?
I had to call in.
Oh, okay. Great. That's fine. Thank you. Bradley Evans, are you on the line? All right. Not hearing a response. I'm not seeing any movement here in the courtroom that would indicate that Mr. Evans is present. And I do see Ms. Schaefer is here. She's the family court investigator. So Ms. Russell, if you want to lead out as far as any issues related to the state's interest.
Your Honor, I believe this just came across my desk yesterday. I believe that the state was previously involved under the cause number, but this is a new matter. And what I understand is on for today does not involve support. However, there is a history of TANF in the case. So if support issues are heard, I would ask that the state be heard on that.
Okay, so you want to is there a pending motion related to any support issues?
Not that I could see, Your Honor. I just wanted to make sure that if support issues are addressed, the state's heard.
Okay, all right. So we're here related to the family court investigator report, and that was submitted, and the recommendations have been made there. And this is based on an earlier hearing where the court needed a bit more input, and Ms. Schaefer has provided that. Let me double check with Ms. Norris. Did you receive a copy of the court investigator's report?
I haven't. I might have on my email. I was trying to find it, but I haven't received it. I haven't read over it, but I did receive it.
Your Honor, I sent it via email and USPS.
Okay.
Yeah, I haven't got it USPS, but or email. I was looking on my email, but I haven't found it yet.
And Ms. Schaefer, it looks like this was sent on July 5th.
Yes, Your Honor.
Okay. And Ms. Norris, are you looking at your Gmail account?
Yeah, which Gmail was it that she used? I thought it was my Yahoo account, actually. Sorry.
Norris?
I think it's S. I don't have a Norris44 at Gmail, I don't think.
And then Ms. Schaefer, the email that you used, where did that originate?
From Odyssey, Your Honor.
From Odyssey. Okay. And that was in the footer of a pleading that was filed?
It would probably be under the party correspondence information.
Okay.
It was a 44 at Gmail.
I think it was Norris.
Okay. I'll try that one.
All right. So it looks like that was sent via U.S. Postal Service on the 5th. So that was sent that would have been on Friday, and today we're on Wednesday.
I didn't check my mail yesterday, but as of like Tuesday, I didn't have any.
Okay. Well, what we could do is so Ms. Schaefer in that report provides a lot of information, and she makes some recommendations related to visitation and residential time and transportation and Head Start, hair follicle tests and UAs and the like. We're not, I think, to have you just review it on the fly, that's probably not the best course of doing it. Usually we like to have people and all parties to have opportunity to review things under a non-pressured environment. And I think court tends to be kind of a pressured environment. So one thing we could do is that we could set the matter over 1 or 2 weeks, allow you to digest that, and we could come back and review it and then have some input from you, Ms. Norris. Do you have any questions on that proposal? Ms. Norris? Ms. Norris, are you still with us? She had called in using a phone number, I believe. And so it looks like she may be disconnected because I don't see any phone numbers in the Zoom names. All right. I think we'll need to come back to this matter and just when she comes back on the line, hopefully she comes back on the line. So Ms. Schaefer, if in the next 1 or 2 cases that I've called, if maybe you could just keep an eye out for her, and then we'll be back in 1 or 2 cases that I will next call, and then we could address it at that time. If she's here, great. If she's not here, then we'll kind of decide what we do next.
All right, sounds good, Your Honor. Thank you.
Russell's here representing, appreciate that. Thank you. The state, and then I'll ask if Haley Edmondson Pena is on the line.
Yes, Your Honor, I am here.
Okay, well, then I'll ask if Kenneth Brogan is on the line. He's being represented by Stephen McNeil. Is Kenneth Brogan on the line?
Good morning, Your Honor. Mr. Brogan is here. I've got him here with me in my office. I don't know if you can see him through the camera. There he is.
Okay, great. Thanks, Mr. McNeil. And Mr. Brogan, making sure you can hear me okay?
Correct.
Okay, very good. All right, this is on for the state's motion for temporary child support, and also a motion filed by Mr. Brogan related to a change of venue to Grays Harbor, and also documents related to a parenting plan and other pending motions. So what I propose doing, and I'll get feedback from the parties if you have any concerns about this approach, is that we could address the state's motion for temporary child support, and then I want to address the motion for change of venue, because if the change of venue is granted, I think the issues that are contained within, say, a parenting plan, if it's granted to move to Grays Harbor, it's probably best to be heard in Grays Harbor. So any concerns if we address the child support issue and then address the motion to change venue? Mr. McNeil?
Judge, I don't have any objection to doing the child support. I don't know if the state or if the other party are prepared to address venue, because I didn't receive a responsive pleading to the venue request. So they may not be prepared for argument yet, but I'd have to hear from them.
Your Honor, it is, I am under the impression that the change in venue is supposed to be on the 23rd.
I think that is the case. It's docketed for the 23rd. I think that's correct.
And my response will be in later today.
Okay. All right. So if that's the case, looks like it is docketed for the 23rd of July. Pardon? So the 23rd is a Tuesday, so that may be the issue, as opposed to a Wednesday. Okay. Okay. So Mr. McNeil, just so you're aware, it looks like there was a submittal of a notice of hearing for the change of venue motion that proposed to set it to July 23rd, which is a Tuesday at 1 o'clock. And so it looks like the clerk's office did not set it, and they indicated that they had notified your office. So, so what we can do is that we could set it to this particular docket on, say, on the 24th of July at 9 a.m. if that works for the parties. But I think our approach today would be simply to address the child support issue, and then come back on the 24th if that's agreeable to all parties to address the motion to change venue and associated motions.
And then what time would that be on the 24th, Your Honor?
On July 24th, that'd be at 9 a.m.
Okay, that time and date are available on my calendar. I've just penciled that in.
Okay, fantastic. I appreciate that. And Ms. Edmondson Pena, would the 24th of July at 9 o'clock work for you to address the motion to change venue and associated motions?
Yes, Your Honor.
Okay, very good. All right, so we'll limit our focus today to the motion for child support brought by the state. So we'll hear first from Ms. Russell, then we'll hear from Ms. Edmondson Pena, and then from Mr. McNeil on behalf of Mr. Brogan. Ms. Russell.
Yes, Your Honor. Barb Russell for the state. We're here on the state's motion for a temporary child support order. I'll point out, first of all, that it's temporary, so it will may be subject to changes based on parenting plans and such in the future. The state's address some issues on the worksheets. First, the state used Mr. Brogan's actual incomes from the second quarter of 2023 to the first quarter of 2024 based on employment security data, and imputed his income at 35 hours per week at his actual hourly wage in those periods of time, which was $31.33 per hour. There's no whole family deviation, and there's no residential credit because that's prevented by the receipt of TANF in Ms. Edmondson's household starting in May, based on RCW 26-19-075. Ms. Edmondson's income is imputed at minimum wage at 32 hours per week because she's receiving TANF based on the standard in RCW 26-19-071. Okay. So based on the standard calculations, that comes out to $702 per month. And we're asking that begin in May because the records of TANF show that that's the first month in which the parties reported separate households.
Okay.
I would ask that.
So then you have a net income for Mr. Brogan at 4052 and a net of Ms. Edmondson at 2035?
That is correct, Your Honor.
Okay, thank you. Go ahead. I interrupted you. Apologize.
I would ask that the court disregard Mr. Brogan's filings as to child support for a number of reasons. First, I would ask that they be disregarded. Procedurally, the state first received service of anything yesterday, and it wasn't service according to the notice of appearance by the state. It was sent to a general address. It did get to us, however, not until yesterday that any responses would have had to be filed no later than 3 p.m. on June 26th under local rules, local rule 88. Mr. McNeil did sign a cover sheet on behalf of Mr. Brogan.
You still there, Ms. Russell? Ms. Russell, we lost you there for a second.
I apologize. I've been having trouble with my connection.
Okay.
And then Mr. Brogan's paperwork, I wanted to address the substantive issues there, that he did not do any imputation as required by RCW 26-19-071. And there's a case on point very recently from Division I Court of Appeals, VIA versus DSHS, addressing that. It's unpublished, but it's from April of this year, addressing particularly that section of statute. And the court makes very clear that it's not optional to follow the sequence of imputation standards contained in section 71. And then also that, so it's appropriate to impute Mr. Brogan's income, even though he's currently receiving unemployment. He's got a history of earnings that show that he should be imputed at his recent average hourly wage based on RCW 26-19-071. And then as to the residential credit, again, that is contrary to RCW 26-19-075, particularly when TANF is involved in the household. The language of the statute is specifically when support payments would be insufficient for the household to maintain a standard of living for the child, I think. But there's case law that suggests that receiving TANF is demonstrative that that's insufficient resources in the household.
Thank you, Ms. Russell. Mr. McNeil?
I think the court had indicated it would, next would be Ms. Edmondson in terms of order of presentation.
I very well may have. Thank you. Ms. Edmondson Pena? Do you have
Yes,
any
sure.
comments? Do you have any comments related to the state's motion related to child support?
No, sir, I do not.
Okay. All right. Thank you. Mr. McNeil?
So thank you. So some of the arguments from counsel are well received. I understand the position, but what I did hear from counsel, and it's somewhat disingenuous when counsel indicated she understands that my client is on unemployment, that he is receiving unemployment income, and the state has access to that information. They have access to all the employment and unemployment information, and they deliberately stopped in May because May is when he was laid off. He was laid off from his job as a logging company, Wazak Timber. He's currently receiving unemployment benefits of $377 per week. And I'm sure, as the court knows, unemployment doesn't come without strings. You have to take a job when they offer it to you. You have to go to the unemployment office. You have to sign in, and you have to exercise due diligence. So it's not just something you can sit on and collect without having some affirmative duties. And that's where he's at right now. He's receiving $377 per week, and the state knows that. Also, Your Honor, he had been into, as part of the parenting plan aspect, he was doing his treatment. And he's also enrolled at Grace Harbor College currently right now while he's on unemployment, getting a commercial driver's license, or they call it a CDL. He's estimating the finish to be in August of 2024. So he's very proactive in terms of establishing himself as a wage earner and a provider for his child. And that does not seem to be the case with Miss Edmondson. She isn't doing really anything to better herself. She's not doing any treatment that we can tell. We don't know where she's living. We don't know where she's working. We don't know why she's not working. She hasn't said a reason why she's not going to try and get a job. We don't know why she's on public assistance. And she's been withholding visitation and so far refusing to communicate. So, you know, she's not coming in here with clean hands either, Your Honor. So we're asking that the court impute income to my client at $377 per week, that it be a temporary order as the state had suggested, and that we revisit the matter in August after he finishes the CDL. At that point in time, we should have a more productive hearing. We'll have more information from Ms. Edmondson regarding her treatment and where her living conditions and other adults living in her home and how they're contributing and things of that nature that are all relevant to the court establishing child support. So $377 per week, that's what we're asking for. And I did provide a worksheet. And if counsel wants, I could reciprocate and send another one down there. And I do apologize for the late filing. You know, we were trying to file things with the clerk's office down there, and they were at one point refusing to accept filings, which was kind of odd. And I think what it was there was a crossover. We were trying to file up in Grace Harbor, and our court up here said she had filed down there, but hadn't served or notified anybody up here that there was a matter pending. So we expect to have that sorted out on the 24th. I don't have anything else unless the court has some questions.
I don't. I appreciate the information and presentation. Ms. Russell, do you have any reply?
Just that the standards in RCW 26-19-071 aren't optional. Subsection 6, the imputation of income, it's mandatory language, and that recent case clarifies from the Court of Appeals that the order of precedence in the statute has to be followed. Both Mr. McNeil's worksheets and the state's impute Ms. Edmondson Pena's income based on those standards. So both parties should be neither visitation nor communication are relevant, and what she's doing to better herself, where she's also imputed based on those standards, is also not particularly relevant. To impute a TANF recipient who's also going through the same kinds of strings and not to impute somebody receiving unemployment based on the same standards is just not how it works.
Okay. All right. Thank you. Okay. So what we know as far as the state's motion is that Mr. Brogan is currently on unemployment. Looks like he was laid off in May of some time. He's had a track record of fairly good earnings. He's engaged in a study, an educational program related to a CDL program that he'll be finishing in August, it sounds like. So based on that, the state asked that he be imputed at $4,052 per month net. And they're also asking that Ms. Edmondson Pena be imputed at $20.35, which is a full-time minimum wage. So I think given those arguments and kind of the respective positions, I'll set father's income at $4,052 and the mother's at $20.35 net income both, with a start date of August 1st. I think that kind of provides some understanding of the position that Mr. Brogan is in that he's working to get a different job, and that also shows that he's been a good earner in the past, and likely that will kick up here pretty soon once the CDL is in place. And I think as far as Ms. Edmondson Pena, there may be additional information that comes to light related to her income or job seeking or not job seeking in future days. So the start date will be August 1, and those net incomes will be set for each. So regarding that proposed order, I'm just going to adjust that on paragraph 11, which is on page 3. And other than that, there'll be proportional share for non-covered expenses, including medical and uninsured medical and daycare, work-related daycare. So any other questions related to that order that was presented by the state for child support? Okay. All right. Hearing none, I'll sign off on that order and also on the worksheets that were submitted. And then we will see everybody on July 24th at 9 a.m. For the additional motions. Ms. Russell, do any additional questions or clarifications from your end?
No, I have nothing further, Your Honor. Thank you.
Mr. McNeil?
I don't have anything further, Your Honor. Thank you. And thank you, counsel and Ms. Edmondson.
Okay, thank you. And Ms. Edmondson Pena, do you have any further questions?
No, Your Honor. Thank you for your time today.
All right, that'll conclude the hearing today. We'll see everybody on the 24th. Thank you. Ask it, and I think it looks like Crystal Doughton's going by Crystal Greeley. So Crystal Greeley, are you on the line today?
Yes.
Okay, welcome to you. And then Damon Doughton, are you on the line today?
Yes, sir.
And did I get the pronunciation of the last name correct?
Yeah, Doughton.
Doughton. Okay, Doughton. Thank you. All right, this is a motion brought by Ms. Greeley related to post-secondary support for the child that's planning to attend LCC. So what I wanted to check first with you, Ms. Greeley, it looks like you submitted a docket notice setting the matter for today to be heard on that issue. And
Correct.
but what I had a question is whether you had received the paperwork, basically your motion and other related documents, if you had served those and given those to Mr. Doughton.
Yeah, he was served on 6/9.
Okay, on June 9th. And then was a declaration or proof of service filed thereafter?
I didn't file it because the last time I did this, they said to keep it for my records, but I have it in front of me.
Okay. Let me check with Mr. Doughton. Did you receive a copy of Ms. Greeley's motion to adjust the child support and the declaration that accompanied that?
I did. Her mother had handed it off to me when exchanging my son on Sunday.
Okay. Sunday meaning this most recent Sunday or?
No, I believe it was 4 weeks ago. Yeah, so probably 6/9. That was on Sunday.
Okay, thank you. And Ms. Greeley, that declaration of service that you have from June 9th, that declaration will need to be filed with the court.
Okay.
And if you could just share with me just who the person is that served the documents to Mr. Doughton.
Carrie Williams, which is my mother.
Okay, all right. Okay, so if you could make sure that that's filed today, Ms. Greeley, or tomorrow, that would be appreciated.
Okay.
Then with that issue first being addressed. Let me just double check. I received your motion, Ms. Greeley, and your declaration. I read that, and I also read Mr. Doughton's, looks like a two-page response. Any additional documents that were filed that I should be aware of?
Not that I'm aware of.
Okay, Mr. Doughton.
Nope, just,
Okay.
yeah, I think just what you have in front of you is all that was filed by myself.
All right, great. Thank you. So, Ms. Greeley, this is your motion. So if you want to just go ahead and I've reviewed everything that's been filed related to the motion, but if you want to go ahead and just please state your argument, and then we'll turn the time to Mr. Doughton.
I just feel like our daughter is going off to college, and it shouldn't just be on one of us to help her through her life towards that goal. So that's kind of why I brought it forward now that she knows what she wants to do. And I know neither one of us have a college fund for her to help her out in that aspect. But I would like, hopefully, that we both could agree to support her, with gas and, the everyday life stuff is kind of what I was hoping for.
Okay. And is there any anticipation amongst the parents, you can each address this, as far as your daughter contributing?
To her college?
Yeah, to her college and her educational pursuits.
Yeah. So, what we will have to do is get loans and go from there. We haven't really had any conversations about who's paying for what or whatnot, but it will be on her, and I plan to help her as much as I can.
Okay. And I saw the LCC that it looked like the cost for a year of tuition was $5,582. Does that include books?
That doesn't include books.
So
that's just the tuition.
Okay. And then it looks like your daughter qualified for a Pell Grant in an amount of $2,695.
For a year, yeah.
For 1 year. Okay. And then I just one other question on the FAFSA. It indicated that somebody had an income, I think a gross income in excess of $100,000. To whom does that pertain? Does that pertain to you, Ms. Greeley, or does that pertain to Mr. Doughton?
That was me and my husband's gross income together because we had to put it together.
Combined?
Yeah.
Okay. And so are you, asking for a specific amount?
I didn't ask for a specific amount, no.
Okay. All right. Okay. All right. Anything else, Ms. Greeley, you want me to consider?
No, I just know that just reading up on it, sometimes they just continue either everyday living expenses with the current child support that's in order, or then maybe split it a third for her college. So that's kind of where I was at with that, not really knowing, how he would want to do that either.
Okay. All right. Thank you. All right, Mr. Doughton, I'd like to hear your vantage point.
Sure. So, apologize for my video. The communication, to me as parents, it could be easily been handled if we just had that conversation as parents rather than, because obviously we want our daughter to succeed. But I was just kind of surprised because, it's like I've had this increased emotion, which in the first paragraph, sorry for the 2-page, by the way, but the first paragraph I had mentioned, the last modification, which was less than a year ago, was a 68.5% increase, which has been a big hardship. We're living, paycheck, saving up the little amounts I have, basically paying an additional $1,200 a month, which has, been a struggle. I know it goes towards my kids, which is great. But it's just been tough with basically providing that amount. And then from my understanding too, on the post-second educational is basically strictly just to go towards educational, not expenses related to that, unless it's books. And then, the child's obligated for 30% of that. And I believe the parents are then required to split that additional 70% based off your the prices for the LTC and the 2-year that they applied for.
Okay. Anything else you want me to consider?
Off top of my head, no. I think my nerves are a little bit there, so I'm sure I have more, but as of right now, no, that's it.
Okay, thanks. Ms. Greeley, any brief reply?
No.
Okay. All right. So, the good part is that your daughter has some good plans and has some good ambitions, and that's great. And supporting them as best parents can, it can be a challenge at times, especially college is not cheap. So the first issue that Mr. Doughton raised was the child support order that was submitted back in August 2023. That particular order, although it was a short time ago, it does have a provision in there related to post-secondary education that a parent can bring a post-secondary educational support motion without a showing of substantial change of circumstances. So notwithstanding the brief turnaround time from last fall till now, it's permitted by that particular court order. So it sounds like the daughter is working as a CNA currently, so there's a stream of income hopefully that she can provide.
Sorry, I didn't mean to interrupt. She's actually a server at the Canterbury.
Thank you.
She works 2 to 4 days a week, minimum wage, and she works 3 hours. So, I mean, she doesn't have consistent income, probably enough to help pay for her gas and, doing things with her friends is usually what she uses it for.
Sure. That makes sense. So as a general rule, it sounds like the parties have contemplated this, is that the daughter would be contributing and then the parents would be contributing also to help support kind of the trifecta effort to get her through college. So we know that the tuition for LCC is $5,582 per year. That seems to go up every year. And so the way I looked at this was that each party, including the daughter, has an opportunity to support that educational pursuit. And so if you take that the tuition amount, and you kind of take a look at the proportional incomes that the parties have, and so that would, if I would assign 40% of the tuition to father, 30% to mother, and 30% to child, that's roughly, for the father, that'd be just slightly over $2,200. For the mother, it'd be close to $1,700, and for the daughter, about $1,700 also. And I think also that, looking at this, you can't look at it in a vacuum. There's life that needs to be led. There's gas, there's costs associated with gaining an education, living costs. So I think it's proper to allow for that, those expenses to be paid by the parties. So the way I looked at that is, at this point in time, the child support order requires Mr. Doughton to pay $1,174 per month. If you multiply that by 40%, that would be $470. If you multiply for the mother and the daughter by 30%, that's $352 a month. And so, further calculating, if you take the father's portion of the tuition, which is just above that $2,200, and you put that into a monthly amount, that's $186 a month. For mom and daughter, it'd be $140 a month. And so for the father, if you combine the tuition portion of that the $186 per month, and then the child support of roughly $470 a month, which is 40% of the $1,174, the monthly outlay would be $646. For the mother, if you combine those two, it would be roughly the $140 plus the $342 tuition and child support, $492, and then the child would be kind of in that same boat. I guess I say child, now adult, magically become adults when they turn 18. So that's what I'm leaning towards ruling. And so what that would do, that would change the child support, because child support, ends when a child turns 18, unless there's post-secondary support, and which is being moved for here today. And I think it's appropriate. That seems like both parents, that was the kind of a plan that they'd had, that their daughter would do that. So that would reduce the father's outlay to $656 a month. And, and this isn't, and for Ms. Greeley, it would be basically $492, that her tuition support would be $140 a month, or a total of $1,674, and the same for the daughter. So that's kind of how I calculated it. That kind of spreads the burden across all three parties. And so what I'd ask Ms. Greeley, if you could prepare a post-secondary education order based on those amounts, and I can go over that again, and then have it submitted, or send a copy to Mr. Doughton, and then we'd set a date to come back and make sure that it's appropriate. So
okay, will you say those again?
I will. So Mr. Doughton's proportional share for the tuition would be $2,232, or $186 a month. And then for child support, that would be $470 a month. Basically, child support is the educational support, the payment of the other items that allow a person to focus on their studies. So the total monthly amount would be 656. So that's the 186 plus 470. So the mother's tuition responsibility is $1,674, or an equivalent of $140 a month. For child support is an equivalent of $352, and it's an equivalent of $492 a month when you add those two numbers together.
Okay, can you say the full amount again for the tuition? Sorry, I'm trying to write.
Yeah, 5,582.
Or my portion, sorry, for tuition.
1,674. And then the child's portion is that same 1,674. And then she's also, sorry.
Is that yearly?
The 1674?
Yeah.
That's based on an annual amount for annual tuition.
Okay.
All right. So, Mr. Dowden, do you have any questions about the court's ruling?
I do. Okay, so the 186 for the college support for the post-secondary, I understand that amount, but the 470, I guess I'm a little bit confused, because once the child turns 18, doesn't the support end for Kiana?
Yeah, child support, yeah, it does end, and that there's an understanding that post-secondary educational support is not solely related to tuition. There's books, there's gas, there's food, there's clothing, all those things that make it possible for a person to focus on their studies. So that's part that's subsumed within that post-secondary educational support. So it's not solely related to tuition and books. It encompasses a broader scope of the support that's needed for somebody once they're in school.
Okay, so then my monthly requirement would be $656 for that, and then I still have the other portion that I pay for my son.
This relates solely to the educational support post-secondary of your daughter. So the issue related to any other minor children, that remains unchanged. An important consideration also is that tuition's due at a certain time, and I don't know if they do monthly payments, and so it's an equivalent of, say, $186 a month for Mr. Dowden, or $140 equivalent to Ms. Greeley. That may necessitate some other financial decisions, that maybe take out a loan and then pay it off in a year or something. I don't know how that would work, but it's an equivalent number.
Okay.
Okay.
So then, go ahead, Ms. Greeley.
Sorry, what were you done, Damon?
Yeah.
No, yeah, go ahead. You could.
Okay.
I got
so will that just go through the child support, or is that something that he pays directly to Kiana to put towards her education? How does that portion going to work?
It's a good question, Mr. Dowden. Do you have any input on that?
Yes, I was wondering about that, because I mean, anything that goes towards school, I want to go strictly to the school, and I believe I have that option for whatever those monthly requirements are.
Yeah, as far as tuition, yeah, right. It can be paid directly to the institution. Then do you have any input related to Ms. Greeley's question, as whether the payment goes to the child or some other way?
I'm not sure. I guess I'm still a little confused about the total amount of, because it seems like that's more than my current obligation right now.
Your current obligation is $1,174, correct? But that's for both children?
Yes, for both children.
That's a good point. I didn't take that into consideration. I used that whole number for both children, and coming to that figure of that 1174. I didn't separate it out, so that would reduce it in half. And that would reduce Ms. Greeley's portion in half also. So 470 would be the normal obligation. You divide that by 2, 6, 105. It'd be
currently he pays $587 per child.
587.
Yeah.
Okay, so that would go down to 235.
Well, it would be 587 reduced by 0.4. So basically, it's 40%. You'd be paying 40% of the 587. So I should probably get a calculator. So 40% of 587 is 234.8. And I'm glad you caught that. That was my error. Thank you, Mr. Dowden. And then, so it'd be 234 of post-educational support. And then for Miss Greeley, your figure with that 352 by 0.3, be 0.6, 15. So 30% would be 105.60. So 105.6, and the same for the daughter would be kind of her anticipated contribution to the post-secondary educational support. So the numbers are modified, and I apologize for that error. So father's tuition obligation 2,232, mother's 1,674, daughter's 1,674. Monthly support, educational support for the daughter would be $234 for dad, and 105 for mom, and 105 for daughter.
Okay.
Thanks
And
for
then
that.
is that usually done through child support like we already are doing? It just gets switched to 234 for her a month?
That's a really good question. I don't know. I think as a general rule, child support office bows out once the child turns 18, and
Okay.
I don't think they get themselves involved. So it may be just a transfer to either the parent or to the child.
Okay. I just want to make sure it's done, just because we have other things that are supposed to be paid to me when I pay it and it doesn't get paid. So I just don't want to be out the money, for her for things.
Right. I think as a general rule, the money should be transferred to Miss Greeley for the benefit of the child. And then that could be, there's a little more oversight with that potentially than to her directly.
Okay.
So today being the 10th, let's set this matter over to the 24th of July for the presentation of that order.
Okay.
And so if you'll prepare that, Ms. Greeley, and then forward a copy to Mr. Dowden so he can review that. And then if there's any disagreement as to what the court ordered here today, then that disagreement can be expressed on the 24th at 9 a.m.
Okay.
Mr. Dowden, any questions?
Can you repeat? So I got the 234.8. What was the other obligation with the modified numbers?
Yeah, so the tuition, your portion was 2,232. The monthly educational support was 234, and then 105 for both mother and daughter.
Okay, so 234 is my only obligation right now.
And the tuition of 2,232.
Which is, and that's annual, or is that for the 2 years?
That's an annual amount. Yeah.
So divide that by 12, and then that's.
I think that's 186. And then the monthly child or the monthly educational support would be 234.
Okay.
And then she turned 18 August 11th. So that 200, I wrote it here somewhere. 234.80 would start after that.
I think so. Yeah, I think that's appropriate. That it would, the start date would be August 12th.
Okay. I just want to put those dates in there so that we're both on the same page.
Great. Any final questions?
And then the paperwork presented to me once the new paperwork's filled out.
Right. Miss Greeley will prepare the order. She'll forward a copy to you. She'll forward a copy to the court for review, and then we'll be here on the 24th to make sure everybody's comfortable with that. What's been presented is what the court ordered.
Okay.
Okay. Great.
Okay.
So
Thank you.
We'll see everybody on the 24th at 9 a.m.
Okay.
All right. Bye-bye.
Great. Thank you. All right. And you're Miss Anglin? Yeah. Okay. Welcome to you. And is Eric Dorland here? Eric Dorland, are you on the line? All right, Mr. Dorland, if you are on the Zoom call, if you'd please make sure that you're unmuted, and please unmute and state your name. All right. I did a keyword search with the name Eric and Dorland, not finding any response. I'm not hearing a response, seeing a response from Mr. Dorland in the courtroom. I see that there was service being allowed by Mel on June 20th, and that on June 20th, the petition summons, proposed parenting plan, declaration, notice, motion for adequate cause, order on adequate cause was mailed. So I'll make a finding that service was proper. And this is a motion related to adequate cause and modification of the parenting plan. So with no response from Mr. Dorland and him not being here today, I'll grant your motion for adequate cause and your motion for a change of the parenting plan. And let me double check. You submitted an adequate cause order And did you submit the parenting plan by chance?
Yes.
Do you have a copy of it by
I do
chance?
have a copy.
Okay, so I think you filed it on June 17th. If you don't have a ready copy there handy.
I'm sorry, it's just not stable together.
Oh, no, okay. Yeah, I was just going to offer that if we could print the one that you had filed. Okay, Ms. Englund, I've signed off on that parenting plan. And let me just, I need to make one adjustment to it because it says it's a proposal, but it's actually order. Okay, so I've signed off on the parenting plan, and then if you just kindly just add your signature to that, it'd be helpful. Sure, now it's court's a hard place to be. Okay, very good. All right, so Ms. Ng, I signed off on the order to establishing adequate cause, and I signed off on the parenting plan. Do you have any other questions? Okay, all right, that'll conclude the case. If you're here, make sure you're unmuted and state your name, Stephanie Lakey.
Yes, Your Honor. Here, Stephanie Jones.
Stephanie Jones. Okay, that's might be why you weren't responding. Okay, Ms. Jones is present, and then Kenton Lakey, are you here today?
Yes, Kenton Lakey is here, and good morning, Your Honor.
All right, good morning, Mr. Lakey. We're here on a review of visitation. We had a hearing back on April 10th of 2024, where Mr. Lakey had visitations ordered for first and third Saturdays unsupervised and out in the community, and then second and fourth weeks would be reunification counseling with himself and the children or child. And then it set a review for today to review the status for unsupervised community visits. So that's kind of where we're at. And I'll just double check with the parties to make sure that that was your understanding of why we're here today. Ms. Jones?
That's correct. That's my understanding.
Okay, Mr. Lakey?
Same.
Same, okay.
Yes.
And just confirming with both of you, when I looked at the file, I didn't see any new submissions giving me any update related to the status of the unsupervised community visits. Did either of you submit anything that I apparently had missed?
No,
I did not.
no,
Okay, so all right, so neither party submitted anything. So was it your plan today to provide oral feedback or just a verbal feedback from your respective positions?
Yes, Your Honor. That was my position.
Okay, Mr. Lakey?
Yes, same.
Okay. All right, great. Well, I think we're all on the same page. We'll have to see how it goes because there may be some difficulty. You know, sometimes when we come to court, as a general rule, we have a written response and we know what everybody's cards are, if you will. It's been laid out on the table. We know what the respective positions are. Here today, where we don't have that written information, there's going to be some verbal feedback here today from both of you, which will be new to me. And it'll be new to both of you. And so we may need to, we can address issues today, or it may require that it be set over, just depending on how things play out. So just want to just give you a heads up that that's a possibility. So Ms. Jones, you're the petitioner in this matter. So I'll hear from you if you want to give me your perspective on what's happening on the status of those visits. And then Mr. Lakey, if you could do the same, please.
Okay.
Thank you, Your Honor. My perspective is those visits are actually going well. Our daughter reports enjoying those visits. She reports feeling safe during these visits. And I don't have concerns regarding the visits between my daughter and Mr. Lakey.
Thank you, Ms. Jones. Mr. Lakey?
I feel the same way. They've gone very well. And I was apprehensive at first, but they've gone very well. In fact, Barbara asked me to ask today, because they have gone well, and the feedback from our last visit, that to see if I could get more time, but the extra time after 3 hours would be up to Rosie's time. If say it's 6 hours, but Rosie gets tired or something and wants to quit at 4, that's her, up to her.
Okay. All right.
And we're down to also one counseling session a month to check in after the third weekend right now. So either a half hour or an hour. And this last session was 50 minutes.
Okay.
Yes, Your Honor. I do have some feedback regarding the ongoing counseling. My daughter still reports not having a rapport with Ms. Brandhorst. And honestly, from my perspective, it's just a drain on Mr. Lakey's finances to continue those visits with Ms. Brandhorst. Those visits are not going well. My daughter does not feel heard. My daughter does not feel safe in that environment with Ms. Brandhorst. Okay.
And so, Ms. Jones, do you see any benefit continuing that?
I do not at this time, Your Honor.
Okay. Mr. Lakey?
Yeah, She hasn't been communicating from when we started, but this last, they've been half hour up until this last one, and she was actually very communicative with Barbara and everything. That's why it went longer and went 50 minutes instead of a half hour. It's up to the court what the court wants to do.
The visits have been a half an hour because that's what Ms. Brandhorst told me. She requested that she keep Rosie for half an hour and then she would let her go if she didn't communicate. And our daughter has historically just sat there for half an hour and not communicated. So it's just really, like I say, I just feel like it's a drain on his finances and it's not a help to our daughter.
Mr. Lakey, do you see benefit in that continuing?
No, not really. But I would like to have that as an option in case something does happen, if that's possible.
Okay. Ms. Jones, so your proposal, and it sounds like Mr. Lakey is comfortable with discontinuing the counseling, and then Mr. Lakey proposes that it remain an option if there needs to be some hurdles or issues addressed in the future. Do you have thoughts on that?
I can agree to that as well.
Okay.
I don't foresee major hurdles or issues being solved with Ms. Brandhorst. That's my only concern.
Okay. So the reports are great. It sounds like both mother and father are pleased that the visits are going well. So that's fantastic. That's good to hear. And that's wonderful. So we'll just note that the visits are going super well. Ms. Jones raises the issue of discontinuing the reunification counseling at this time, and Mr. Lakey concurs with that. And then there's an optional of continuing that if there need to be some hurdles addressed in the future, issues addressed in the future. So I'm fine discontinuing that reunification counseling if the parties feel that that's appropriate to continue it or restart it, or maybe do it with a different counselor. I think that would be fine, and that could be restarted upon agreement of the parties. If you can't agree to the restarting, then just need to note it up for a motion and a quick decision on that, whether it's start or not start. So then beyond that, any other requests from the parties at this point?
I would be in agreement with Mr. Lakey's suggestion of doing longer visits, maybe from 3 to 6 hours. And, with the respect to Rosie, being able to have a little bit of input. I'm in agreement with that if Mr. Lakey's in agreement with that.
Lakey?
Yes, that would be fine, Your Honor.
Okay. I'm fine with that also. So I'm just going to do a brief bench order, which means a handwritten order related to the items decided here today. And so one will mention that today's review, that the visits are going well between Mr. Lakey and daughter. So it reads, today's review shows the visits between respondent and daughter are going very well. And I'm going to write the reunification counseling is no longer required, but may be restarted by agreement of the parties or by motion. And then lastly, with input of daughter, the visits between respondent and daughter may be increased up to, I think it was 3 hours was the proposal.
Yeah, up to a total of 6 hours. They do 3 per week.
Okay, Mr. Lakey?
Yeah, 3 right now, and then with the option for Rosie to decide if she gets tired or something and wants to, go back home at 5 hours or whatever, or go the full 6.
Okay, so that,
but at least 3, but at least 3 hours.
Okay, so with input of daughter, the visits between respondent and daughter may be increased up to a total of 6 hours with a minimum of 3. All right, so I'll go ahead and sign that order, and both of you can certainly check with the clerk's office and get a copy of that order. Do either of you have any questions at this point?
Your Honor, yes, I do. I would also ask that the continued condition of Mr. Lakey's girlfriend not being present at visits continue.
Mr. Lakey?
She hasn't been present at any of the visits so far.
No, she hasn't, because it was court ordered that she not, and I just asked that order continue.
Mr. Lakey?
that's fine for now.
Okay.
But in the foreseeable future, that might change because of family and everything.
Sure. I'll ask once the clerk has finished making her notations, if you could hand that order back up to me, I'll add to it. Thanks. All right, so I'll just add that the romantic interest of respondents shall not be present for visitation. Obviously, when there's a court order, if one party feels that there needs to be an adjustment, certainly a motion could be noted up and the parties could address that. All right, so thank you both for your feedback and input, and I'm happy to hear things are going well with those visits. Any final items? Otherwise, I think we'll move on to the next case. Ms. Jones?
The only other thing that I wanted to address is, as Rosie enters high school, she is involved in some extracurricular activities, and there may be one weekend where there is an overlap of those activities. So I just ask that Mr. Lakey be committed to working with me on flexibility if need be.
Okay, I won't make any rulings on that. Hopefully the parties can work together for the best interest of your daughter. And so if there becomes a conflict, then again, a motion could be filed and the court could chime in.
Okay, thank you very much.
All right, Mr. Lakey, any final items?
No, sir, Your Honor. Thank you very much.
Goebel, are you here today, Mackenzie?
Yes, I am.
Okay, welcome to you, Ms. Goebel. And then Ian Goebel, are you on the line today?
Yes, I am.
Okay, welcome to you, sir. Okay, this is a motion brought by Ms. Goebel for adequate cause to modify a parenting plan, and then a motion to modify a parenting plan. In looking over the case, I've taken notes on this, and it looks like the most recent order was from October of 2023. Looks like there was an issue related to a criminal matter involving domestic violence. And then maybe a concern related to CPS, brought to the attention of CPS regarding drinking and driving. So I've read the pleadings submitted by both parties, so I'll hear from you first, Ms. Goebel, and then from you, Mr. Goebel.
Good morning. So yeah, we were sharing 50-50 of our son Ian, and it was February 2nd that I received inappropriate text messages from Mr. Goebel, who was intoxicated. There was a lot of messages sent that night. I couldn't provide all of them, as I don't think the courts have time to review all the text messages that were sent that night. But if you look at Exhibit C, I did attach quite a couple text messages that he had sent me, stating that our son is too hard to handle for him, and that he would be okay to give Ian up to me if I took him back to court. He referred to our son as an effer. Not comfortable saying the word in court. However, he also gave Ian up to me on February 4th, which was his parenting week. His parenting week was February 2nd, and he came and he picked Ian up late. And then when I got Ian on February 4th, Ian's cell phone was broke, and we questioned Ian on why his cell phone was broken. We being me and my partner that I am with currently. He told us that his dad was intoxicated when he picked him up and drove him home. He explained the whole scenario of the route that his father took. I went and he showed me where his father drove off road, and there was tire tracks that matched the tread on the car that he was driving. And so I called as a visitation supervisor and mandated reporter. I was to make a CPS report, but I did contact the school counselor and told her what Ian had told me about the incident that had happened that night. Her being a mandated reporter, she also reported to CPS. Within 2 hours, a social worker had arrived at the school to start an investigation on questioning Ian on what had happened. And I got him enrolled in counseling. And during the first session of counseling, that therapist also, per her mandated reporter, had to report to CPS as well. There were some other concerning things that Ian had brought to the counselor's attention and to my attention. If you look at Exhibit D, that is a report that we had typed up of the incident that Ian told us happened that night. So that one I sent to the social worker at CPS as well. following that, Mr. Goebel has not had any contact. His last parenting day, if you look at Exhibit F, the last time had Ian on the 17th. He stated in his report
17th of
March. Yeah, the 17th of March. He has only had one phone call with Ian that was 8 minutes long on April 2nd. That is the only time. And he was told that his son was trying to get a hold of him. His son has reached out and the phone goes to voicemail. One of the weekends, his son reached out. I believe it was something about baseball. His son has reached out and Mr. Goebel was in jail. We looked at the jail roster. He had, on February 13th, he had court. And that's when the protection order between him and I was set in place. So he has not had any contact with me since the 13th, even though the protection order does state that there is a exception in there that he can communicate with me for the sake of our son. He has yet to make any communication. I've reached out to him with baseball schedules. I was letting him know his son was pitching in his first game, and there was nothing with him showing up to any games. He makes the excuse that he is scared to reach out because he's fearful that I will manipulate the narrative. I think it's important, and I encourage him to keep going to counseling. I noticed he stated in his report that he is seeking therapy and he has been diagnosed with PTSD. However, I do not think it is appropriate for Ian to be in Mr. Goebel's care full time and suffering consequences of his PTSD while he's in treatment. I think, my concern is Ian feeling uncomfortable after the length of absence of Mr. Goebel. I did find he's got a tablet that he plays on, and I did find in there that he's been searching up, his dad, and, he's curious about his dad still. And I encourage him that he still reaches out to try to have some kind of relationship with his father. But as in having visitations without being supervised, I think is unsafe for the circumstances right now with his absence that he's created with no contact. So I still do have Ian currently enrolled in counseling at Columbia Wellness, and I know Mr. Goebel does not have a valid driver's license and insurance, and he is still out driving around. I fear that he will drive our son around. I was made aware of his DUI that he got after my son came to me and told me that his dad was drunk while driving. I did call the prosecuting attorney and let him know the incident that had happened. And also with that, I was aware that he had a DUI that he had gotten in Wahkiakum County in October of 2022. And
so that's the only DUI conviction is from the Wahkiakum County matter in October 2022.
Correct. Yeah, that was the only DUI incident was then. But yeah, I was made aware of that after the incident on February, when I got Ian on February 4th, and I contacted the prosecuting attorney, and that's when I found out that he has a DUI and he lost his license and he's been driving our son around with no valid driver's license. So that I put in the parenting plan that he is not to operate a motor vehicle unless he shows proof of a valid driver's license. And I'm also asking that the court take in consideration that Ian has not seen his dad since March 17th, and he has only made contact with Ian one time. And mind you, with the last date of being seen on March 17th, he's only had Ian since he gave him up to me on February 4th on his week. He's only had Ian overnight, and one of those overnights we tried reaching out to him on a Friday to meet up with a friend to take Ian out to his location. And he refused to answer the phone. He stated to my brother next day when we reached contact, he stated to my brother that he had fallen asleep. And to me, that's, there could be multiple excuses to not see your son, but none of his excuses are valid to me on why he's not present in his son's life. His son loves him very much. They did have a great relationship. Mr. Goebel was always a great dad. So since February, I don't know what's been going on, but he has been absent.
Okay.
But other than that, I think that's it. I know our son is just scared to see his dad.
Okay. All right. Thank you. Just one clarifying question, if I may, Ms. Goebel. In your documents that you alluded to that Mr. Goebel was sentenced to a criminal matter in 2024? Or is that just that he's on probation through the Wahkiakum DUI?
So he did get the DUI in Wahkiakum County. He was also on February 13th when he went to court, which is the protection order that was set into place. There was a domestic violence incident that was between Mr. Goebel and I when we were still together. That led to our divorce with an anger outburst and with his use of alcohol. He held me down, pinned me down to the ground. And
so I'm just curious, in 2024, was there a criminal conviction on Mr. Goebel?
Yes, for domestic violence.
For violation of a no contact order, or for an actual incident involving physical contact?
He was charged with domestic violence on February 13th.
So
he was
so assault in the fourth degree?
Yeah, that might have, yeah.
Okay, and that case resulted in a conviction?
I believe so. I know he was court ordered to do hours of community service, and instead he exchanged for, I think that was the jail time that he served.
Okay, and that was for an assault that occurred on February 13th?
That was an assault that occurred from December of, I want to say 2021 is when the domestic violence incident happened, but he didn't follow the court order, and so they charged him with it on February 13th of 2024.
Okay, so it's kind of like a stipulated continuance or a deferred prosecution or something of that nature.
Yeah, because they weren't going to put the domestic violence on his record or the assault on his record if he followed the court orders that he was supposed to do. And from my understanding, he didn't follow those court orders. He said that he refuses to go to therapy and get the help that he needs, and so they decided to charge him. And then because of the text messages that he had sent me, stating that I have what's coming to me, then I did ask the prosecuting attorney on that day to please put a protection order between Mr. Goebel and I for a year.
Okay. And was that order entered?
It was. Yeah.
Okay. All right. Okay. Ms. Goebel, thank you. We'll hear from Mr. Goebel. Mr. Goebel?
Yes, Your Honor. So I understand I didn't necessarily make the best decisions that night. That kind of have led me to where we're at right now. And I'm not disagreeing with what she wants to change in the parenting plan, but I noticed in the parenting plan that there was no progression of it ever not being, non-supervised. So that's why I put in my parenting plan to have it be a little bit more progressive. Start out with supervised visitation with a professional or otherwise agreed upon third party, and then maybe progress to all just doing one day, maybe no overnights for a little while, and then just work into weekends again. I would never intentionally put my son in danger. The night in question, I was not intoxicated. Yes, I should not have been driving that night because of my suspended license. However, I was not under the influence of alcohol. The other night that Miss Goebel had brought up was the one where she had mentioned that I fell asleep, and yes, I did fall asleep. I had talked to the person doing the pickup and drop off, and they had stated that it was going to be pretty late at night, and it was almost 10 o'clock at night is when she said that they were going to be dropping Ian off. So, I mean, I did fall asleep. It was a Friday night. I worked all day. And as far as not communicating with him, it is true. I am worried that Ms. Goebel would skew what was actually said and use it against me. And that's the reason I never went to any of his baseball games as much as I wanted to go. I watched all last season. I love watching him play, but the restraining order says I can't be within 1,000 feet of her. And there's nowhere in that baseball field that I could see him play and still be 1,000 feet away from her. And whether she's the one that calls or somebody else calls, I don't want to risk getting in trouble for it.
How long is that no contact order valid?
Your Honor, it's valid for a year.
It's 1 year. So it'll expire in February 2025.
Yes, sir, it will.
Okay. All right. Thank you.
Ms. Goble and I also had a verbal agreement that I was going to let her take Ian for a little while I paid off some debt and got moved into a little bit better of a living situation, which I have gotten moved into a better living situation. And been working on paying off debt, which was the original agreement that we had, and things obviously have kind of spiraled for the worst since then.
Any other input you want me to know or be aware of, Mr. Goble?
Not off the top of my head, Your Honor.
Okay. All right. Thank you. So there's a request by Ms. Goble for you to get an SUD or a substance use disorder evaluation, and if they recommend treatment, then do treatment. She's also recommending a mental health evaluation and if applicable, a treatment. Do you have any position on those requests?
I mean, as far as drugs and alcohol treatment goes, I went through the treatment for my DUI already.
When you say you went through it already, when did you complete the treatment?
I completed it after I was convicted of it, so somewhere around probably April of 2023.
Okay. Okay. And then as far as the mental health evaluation, do you have any input on that?
I don't have a problem with that at all.
Okay. All right. And then as far as the status of your driver's license, do you have any concerns if there would be a restriction that said that you wouldn't be able to transport child until you have a valid driver's license and proof of insurance?
Yeah, I won't transport him until I do, and that's why we need to find a reliable third party to help out with that until I can get that taken care of.
Okay. All right. And then do you have any information related to any status updates of the CPS complaints? If you've received any contact from them, if you've received any founded, unfounded letters?
So I have not received anything from them. Well, no, that's not true. I only know about one of them, and as far as I was concerned, I was under the impression that it was getting closed. And this was March of 24. Amy Farley is the one that took care of it. She got a hold of me and we talked about it and said there was no reason to further pursue this case. So last time we were in court on the 26th of June is when I found out that there was 3. I had no knowledge of them.
Okay. And then so no formal correspondence from CPS related to any status updates or closure or continuation or founded, unfounded?
No, sir.
Okay. All right. Okay. Anything else, Mr. Goble?
No, sir.
Okay. All right. Thank you. Ms. Goble, I'll give you just a brief moment for any reply.
Okay. So he said that there wasn't any limitations for the supervised visits. I did put limitation on supervised visits until the CPS investigation is complete and Mr. Goble's mental health evaluation, until he has one, and a substance abuse evaluation, whether that, is a hair follicle. However, I am willing to finance the drug test, the substance abuse. I'm willing to finance that as long as it does come back negative. If it comes back positive, I would like Mr. Goble to reimburse for the drug test. I know he mentioned Ian being dropped off late was due to a baseball game, and he was aware that he was going to be dropped off late for that. There is an exception stating in the protection order that he is allowed to communicate with me for the sake of the child. He is allowed to call my phone to talk to his child. I have never told him he could not. He also has that when he did call Ian for the 8 minutes on March, April 2nd or something like that. I think it was April 2nd. He did contact my significant other's cell phone to talk to Ian. So he has had that option this whole time. But it does sound like, I mean, he is agreeing to supervise visits, but I did put limitations in there that it will be lifted once I do receive, you know, the things that I had asked for. And then I also ask that visits take place on the first, third, and fifth Saturday from 12 to 6, supervised or unsupervised, for those until our child feels comfortable enough regaining that relationship with his dad. I've been currently working with support enforcement for child support. I don't know how far back I can backdate for child support. But that is something that I am asking take place, is that he does pay child support and maybe backdate, since I've had Ian since February. I'd like it to be backdated since February, but March if possible.
So Ms. Goble, just on that last point, as far as child support, there's not a pending motion that I saw related to child support. So the oral motion today, I'm not going to entertain it. If that's something that you're seeking, then you'd need to file a motion or work through the administrative channels of child support.
Okay.
Okay. Thanks for the parties. I appreciate that. So, one last question, Ms. Goble. As far as the no contact order, you mentioned there's a carve-out exception for communication with the child that allows Mr. Goble to communicate with you regarding the child. And is there also a 1,000-foot restriction in that no contact order?
Yes, exception of the child. So if I know we do our child swaps or per the paperwork at the police department, however, with him not having a license, we haven't been able to do that. So there is 1,000 feet. However, there's an exception with our child. So baseball games run in that exception because it has to do with our child.
Do you have a cause number for that case?
For the protection order?
Mm-hmm.
I don't. I actually don't even have the protection order in front of me.
Mr. Goble, do you by chance know the cause number?
No, sir, I do not.
So there's a 1,000-foot geographic restriction that prohibits Mr. Goble from being within 1,000 feet of Ms. Goble. And do you recall, Mr. Goble, is there a specific language as far as an exception that says that there's an exception that you can be in a closer proximity if you're watching a baseball game or something maybe more general than that?
The only exception that I am aware of is the communication that we could have between the two of us. But I don't remember them saying anything about space. How did you put that? The geographical location to each other.
Yeah. Okay. And Ms. Goble, you don't have a copy of that order?
Not on me in front of me. I know I do somewhere. It might be down in my filing cabinet with all the other paperwork that I have.
Okay. All right. Thanks. Okay. So I'm going to make a finding of adequate cause. I think there's adequate cause to modify the parenting plan. I think it was best summarized by Ms. Goble that there's been a big change in dad, or Mr. Goble. He said it indicates that he's a great dad, and then there's been a rough patch here, and that he's been absent. There's been issues with the alcohol. There's been some concerns related to that, and also it looks like a kind of a revocation from maybe a stipulated continuance type case in February of this year related to an incident back in December of 2021. So I'll make a finding of adequate cause. Then moving forward, I think modification of the parenting plan, at least for a period of time, I think is appropriate. So there's been a period of time, and not knowing the specifics of that no contact order, it sounds like if there is that 1,000-foot geographic restriction, I can understand why Mr. Goble wouldn't want to go to a baseball game. I mean, he'd want to go to the baseball game of his child, but if there's a chance that he's going to get arrested, then he's going to err on the side of caution and not go. I can see where a person would make that decision, and that would be kind of an excruciating decision because you certainly want to see your child play baseball and let them know you're supporting them and the like. But if there's that restriction there and there's a potential of being arrested, and then I can see why a person may not do that. There is an exception for communication with the child, and maybe that's been a bit lacking. But then there may be some concerns related to that about getting in trouble if it's interpreted in a different way than it was intended. Nonetheless, there's been an absence there between child and father. The child's 10, I believe. So I think that we'll modify the parenting plan in the following manner. That is related to the first and third and fifth Saturdays of each month. There'll be visitations with Mr. Goble and Ian on a supervised basis. It can be a lay person, just agreed between the parties. It doesn't have to be a professional. And it'll be supervised until Mr. Goble completes a mental health evaluation and commences, if applicable, any recommended treatment. Same for a substance use disorder evaluation. I recognize Mr. Goble indicated that he completed that in April of 2023. There's an indication here that there was some alcohol consumption and alleged driving while intoxicated or after drinking with the child in February, I believe. So just to err on the side of caution, I'm going to require that SUD evaluation be completed with collateral input from Ms. Goble. And if that evaluation says then treatment's necessary, then Mr. Goble would need to begin or commence that treatment. So it'll be supervised up until that time. So once those conditions have been met, that the mental health evaluation has been completed, the SUD evaluation has been completed, and any recommended treatment has been commenced, then it can go to unsupervised that same period, the first, third, fifth Saturdays from noon to 6. At any point, Ms. Goble can request a hair follicle test, and that hair follicle test would have to be submitted to within 4 hours, and she would have to prepay for it. And if it comes back that it's clean, then she just eats that cost. If it comes back with any substances, then Mr. Goble would need to reimburse her for that cost of that testing. So once the unsupervised visitation is ongoing, that'll be for a period of 2 months. So once the 2-month period has ended, then after the 2 months, then it will go to that same first, third, and fifth weekends from Friday after school or 5 p.m. if it's not school until Sunday at 5 p.m. And that would be a period of 6 months. And then after the completion of that 6 month after the visits, and there's a continued compliance with any recommended treatment of mental health or SUD, then it can revert back to the 50-50 plan. But before we do that, I want to have a review hearing. But that's kind of where the court's thinking. I think that there was something pretty dramatic that happened. Then there'll be this period of coming together again and getting back in the groove, if you will, and making sure that everything's okay with Mr. Goble and that the child is safe and well. And then after that completion of the weekend visits for 6 months, then a motion would need to be brought for a review / a motion to expand back to the 50-50. So with the driver's license, the transportation of the child, Mr. Goble would be restricted or prohibited from doing that until he has a valid driver's license and proof of insurance. In between, I think joint decision-making is still important. And so I'm going to order the joint decision-making related to medical and educational and extracurricular be joint. And that's allowed in the no contact order based on the communication regarding the child. So that's the court's order. I'll ask Ms. Goble, since you are the moving party, I received an adequate cause order and I've signed off on that. I didn't see a proposed parenting plan that matches with what I ruled here today. So I'd ask that you prepare that and then mirroring the court's ruling today, and then provide a copy to Mr. Goble, and we'll set it for review on the 24th of July at 9 o'clock in the morning to make sure that proposed order captures what the court ordered here today.
Okay, so I need to put together a parenting plan with what you just talked about and went over, serve Mr. Goble with it, the court, and then we'll revisit the parenting plan on the 24th and have it signed off. Is that?
Yeah, basically that's what it is. The presentation is to sign off on that proposed order that memorializes the court's decision today.
Okay. And I heard you mention something for two months you said would be supervised visits. If he does what he needs to, the next 6 months will be limited visits to the first, third, fifth Saturday, and then open to going to 50-50 after the 6 months.
Correct. So it starts out the noon to 6. It'll be supervised until the mental health evaluation and the SUD evaluation have completed and he's begun treatment if recommended. So then once he's completed those, and if treatment is recommended and he started that, then it can move to unsupervised. So there's not a time frame on that. And then once he's completed that, and then that would be for that period of time that you mentioned, and then the 6 month period.
Okay. And I know I know he has been hesitant to contact me. I'm curious how because our son doesn't have a phone still. He hasn't given his cell phone back. It's also broken. I know he stated in his response that he's willing to provide Ian with a cell phone. I'm actually looking forward to getting Ian a new cell phone and getting him back on our cell phone plan. However, if he's wanting visitations to happen, I need some kind of communication from Mr. Goebel that he's comfortable with.
So if the no contact order says that the parents can communicate regarding the child, then Mr. Goebel is free to contact you and communicate with the child. And if either party wants to get the child a phone, either party can get the child a phone, and there can be communication through those means also.
Okay.
So any questions on your end, Mr. Goebel?
Just so we're clear, I can contact her regarding Ian, and I don't have to worry about any kind of repercussions.
So I'll just give this just with a bit of a caveat. I haven't reviewed the order. I haven't been given a copy. No party's read it to me here today. I'm working on the assumption that there's a no contact order that allows for an exception that allows parents to communicate regarding the child. And if that's the case, then the parties can communicate regarding the child. If there's any concerns related to what that order does or doesn't say, I would suggest contacting legal counsel to review that and advise you as to the scope or the breadth of it.
Okay.
Okay, so Ms. Goebel, any final questions?
For the supervised visits, because it can be third party, you said it has to be, so I have to agree on who he can use for supervised visits, right?
Yeah, it cannot be unreasonably denied. So there has to be agreed supervisor, and that agreement cannot be unreasonably denied.
Okay.
Any other questions?
No, that's it.
Okay, so we'll see everybody on July 24th at 9 o'clock. If the parties agree that with the order that's presented or prepared by Ms. Goebel, if she got it right, in other words, she summarized what the court ordered here today, then neither party would need to be here on the 24th. You could both just simply sign off on the order and present it to the court for signature. However, if there's any disagreement or question, then I'd expect to see both of you here with that proposed order.
Okay.
Okay, that'll conclude the hearing today. Thank you.
Thank you.
I'll ask if Jeffrey Bierbauer is present.
I'm present here, Your Honor.
Okay, welcome to you, sir. And then I'll ask if Ashley Bierbauer is present.
Yes, I am, Your Honor.
Welcome to you, ma'am. I also note that guardian ad litem Height is here. Ms. Height, can you hear me okay?
Yes, good morning, Your Honor.
Good morning. It's still morning, just barely. All right. So we're here today on Mr. Bierbauer's motion for contempt. And it looks like Mr. Bierbauer served a copy of his motion and the order to show cause on Ms. Bierbauer on June 27th. The concern with that is that it's a shorter period of time than the rule calls for. And so my concern is that we know what Mr. Bierbauer's alleging occurred via the contempt. However, there's been not enough time, according to local rule 88, for Ms. Bierbauer to supply a response. So my initial reaction to the motion is that there hasn't been the sufficient time between the time of service of the documents on Ms. Bierbauer and today's hearing to allow her adequate time under the rule to respond. So I'll hear from the parties if you have any comment on that, Mr. Bierbauer.
I do. I tried for a week to have her served, and my people that served knocked on the door every day for a week, and they could hear her in the house. She would not answer the door. So I don't understand how this is not enough time when I served her on the 27th, and it's now the 10th of July. That's more than the 7 days that's allotted.
When you say the 7 days, when you're referring to that, where's that information coming
That's
from?
what I was told, that I have to do it within 7 days.
Okay.
Or whatever. But this is the third time I've been at contempt and nothing's been done. I need something done because it's not healthy for my boys to be where they're at right now and who she has around.
Okay. So I'm making reference to local rule 88, and it indicates here the following. It says all domestic relations motions shall be filed and served upon all parties not later than 21 days before the time specified for the hearing.
Okay, I was never informed of that rule.
Sure.
By the court system.
Yeah, it's not uncommon that people aren't aware of all the different rules that apply to a particular hearing. And I recognize that providing service in a timely fashion can sometimes be really tough, and sometimes it doesn't happen super fast, and it takes multiple attempts, and sometimes people try to avoid service too. So with the service on the 27th to today being the 10th, I think that's a total of like 14 days roughly. So we're a little bit shy of that 21 days. So what I'm proposing is to set the matter over 2 weeks to the 24th. That would be beyond the time required by a little bit, and that would allow Ms. Bierbauer to supply a response to the court and also serve a copy to Mr. Bierbauer, and then the issue can be addressed and decided by the court. Any questions on that approach if we were to come back on the 24th?
The only issue I have with that is I can't be missing work. I mean, I missed work today. I'm the sole driver at my company, and I had to pull tooth and nails to get covered. So I'm having a hard time missing work because I'm also losing out on money to support my children.
Right. It's kind of a catch-22 in a rock and a hard place. I recognize that. So then would the 24th work for you or not?
It'll work. I just have to see if I can get somebody to cover me.
Okay. All right. Ms. Bierbauer, as far as your response, you'll have opportunity to file a response to the motion that's been filed by Mr. Bierbauer. You'll need to file a copy with the court and also send a copy to Ms. Height and send a copy to Mr. Bierbauer. And then we'll be here on the 24th to hear your respective positions, and then I'll make a decision on that motion for contempt. Do you have any questions?
No, Your Honor.
Ms. Height, do you have any questions or comment?
My only comment, Your Honor, would be to ask the court to remind Ms. Bierbauer that per the last hearing, the guardian ad litem recommendations were adopted that prohibited Mr. Williams from having any contact with the children. And I would like to make sure that she is aware of that going forward, just as a safety consideration for the boys.
Your Honor,
Thank you, Ms. Height. Ms. Bierbauer.
I want it known by everyone in the courtroom that my sons have not had a conversation nor have been in the same room with Derek Williams since I think the court decided back in April he had to move out of the house in 2023. So I am aware, and I am not having him around my children.
Okay. All right. Yeah. So Ms. Height just rehearsed what was contained in the September 28, 2023 order under section 14.2, which states the children are to have no contact with Derek Williams or be present at the mother's residence during any of the mother's on-duty parenting time. So that's a valid court order, and Ms. Height was just drawing all the parties' attention to that. So we will be here on the 24th of July. We'll look forward to hearing from both parties at that time. We'll see everybody then. Thank you.
Thank you,
Your Honor.
Why did you not ask to talk again?
I tried to, and he ended.
Eric Solis, are you here? Next week. Eric Solis, if you're on the Zoom call, if you'll please unmute and state your name so I know you're present. All right, there's no response. Cagney Solis, are you present?
I am, Your Honor.
Okay, thank you, Ms. Solis. And is that the correct pronunciation of your last name?
It is. Thank you.
All right, very good. So this is a motion brought by Ms. Solis related to the mortgage on the home or the sale of the same. It looks like service was provided to Mr. Solis on May 31st with a petition and the motion and sealed financial documents and with the docket notice for today. And he's not here. So your request, Ms. Solis, is to list the house for sale and require everybody to sign off on all documents related to the sale and listing, and allow for $5,000 each for moving costs after the home sells, and that the sale proceeds would go to trust. Is there anything else to your motion?
My only question on this is that I apologize. I've never been through anything like this. He had originally agreed, and then he kind of backpedaled. I got the realtor. I've got everything set up. My only question is when it comes to the things that need to be fixed at the house, I am the only one that he hasn't worked in 2 years. So I am the one that's doing all the, coming up with the money for the home warranty for fixing the things that he has broken in the house. And I am requesting to see if I could get, I would say $2,500 to $3,000 more once the house sells, because of me having to fix the things. I have to get the septic pumped. The heat pump, the furnace is no longer working. The microwave has quit working. I'm the one that is paying for all those things, even though I'm not residing at the residence.
Right. So your request is that, in order to get the house prepared for sale, there's need to be some repairs, and you want to be compensated for those.
Correct.
Once the house sells.
Yep.
So that would be a separate motion that once the house has sold, that there would be additional dollars that you would bring forth and say, hey, these are the dollars that I spent in getting the house ready, and I want to be compensated for that.
Okay.
And so you'd need to file a separate motion once the house sells.
Okay.
So with proper service and Mr. Solis being given notice of all your requests and him failing to appear today, I'm going to grant you a motion that allows you to list the house for sale, and that requires all parties to sign documents related to the sale of the home and the listing of the home. I'm fine with the allocation of the $5,000 each for moving costs once the home sells. Obviously, when the home sells, that there will need to be the proceeds would have to go to the trust account that you specified in your motion. That's the trust account of the attorneys of the firm.
Yes.
And then, so what I'll need you to do, if you would please, I'd look to see if you've prepared what we call a proposed order, meaning if everything goes your way, you would have proposed an order that lists basically that you asked for everything that you got, which in this instance you did, except for that one item as far as the repairs to the home. That's going to be a separate matter. So I would ask you to submit a proposed order and submit that to the court and send a copy to Mr. Solis. And then we would be back here on July 24th to review that order to make sure it complies with everything that was in your motion. And then
So when it oh, sorry, I apologize. So on the proposed order, would that just be the sale of the house?
Yeah, the motion for the listing and the sale of the home and reasonable and signing off on documents related to both, and then the $5,000 each for moving costs once the house has sold, and then that's dictating that the proceeds of the sale go immediately into trust or held in trust, but allowing for that $5,000 each to be distributed.
Okay.
So if you could prepare that and then submit it to the court in preparation for the hearing on the 24th and send it a copy to Mr. Solis, that would be appreciated.
Okay, and that would be at 9 o'clock, 9 a.m.
Yes, 9 o'clock on the 24th of July. We have Mr.
Awesome.
Jensen
Thank
coming
you so
forward.
much.
He's present. That'll conclude the
Thank
courtroom. And then
you.
Megan Rhodes, are you on the line today? All right, Ms. Holder's here, I see, representing Ms. Rhodes. She's present. And I see that Mr. Lawrence is also present, the guardian ad litem. On last time we were here on the 26th of June, we postponed any adoption of the GAL recommendations related to Mr. Pittman, who's the boyfriend of Ms. Rhodes. Ms. Rhodes was given some time to seek a no contact order related to Mr. Pittman. I presided over the hearing or the docket, the protection order docket on Monday. That was, I don't remember exactly. I can actually go back and pull that up and tell you what happened. What I do know is that I don't think the order was granted. There was some procedural irregularity, and the parties may already know this. And
Yes, Your Honor, if I may refresh your memory, there was a procedural error as Mr. Pittman had not yet been served, and so the hearing was set over until July 22nd.
Thanks for the reminder. So the 26th of July, set it up to 22nd of July at 1 p.m. Okay, so thank you, Ms. Holder. I appreciate that. So that's kind of where we're at, is that there was concern related to Mr. Pittman, and that there was that Mr. Pittman, Ms. Rhodes would get a no contact order related to Mr. Pittman. There were some service issues, and so it was set over to the 22nd of July on the protection order docket to seek that. So that's kind of where we're at this point. I'm not sure if there's much we can do today related to that, but I'll hear from the parties. So Mr. Lawrence, and then Ms. Holder and Mr. Jensen, we'll just hear from you in that order, please.
Your Honor, this morning I was able to review an email from Ms. Holder indicating that Ms. Rhodes has some information that there are two issues that could affect the sobriety of Mr. Jensen. One is there's a gentleman who is a close friend of his who he also works with that may be getting into selling drugs. And also Mr. Jensen, it's alleged, received a call from his current girlfriend, Tiffany York, indicating he had to come home right away because she was on the verge of relapsing. When I couple that with the postponement in the protection order request, my recommendation to the court would be to postpone the matter until the end of July or 1st of August to give me a chance to speak with both Ms. Rhodes and Mr. Jensen to find out whether any of those allegations are accurate, and if so, what plan has been put in place to resolve the issue. So at this point, that would be my recommendation to the court.
Okay, thank you, Mr. Lawrence. So there's some more information you want to look into, and you want to see what the result of the protection order is. And so looking at end of July, first part of August for kind of an updated report on your end.
That's correct.
Okay, all right, thank you. Ms. Holder, and then Mr. Jensen.
Yes, Your Honor, I don't have anything to add from what Mr. Lawrence has said. I completely agree. A set over would be appropriate to address the anti-harassment protective order issue, as well as investigate these other concerns about Mr. Jensen's potential sobriety.
Okay, great. Thank you. Mr. Jensen.
Yes, Your Honor. I have not relapsed. I don't know what is being talked about. Tiffany possibly relapsing. I don't know anything about that either, but okay.
Okay.
Your Honor, if I could.
Yeah, go ahead.
I would ask that the status quo be maintained in the interim so that Mr. Jensen can continue with his visits.
Ms. Holder?
I have no objection to that. I think the status quo is appropriate. There's nothing right now that would indicate it should change. It's just that these allegations need to be investigated for a final report to make recommendations for a final parenting plan.
Mr. Jensen?
Yeah, I was also notified yesterday that Megan may have been in Florence with John Pittman for the July weekend.
Okay. And then if you want to share that information to Mr. Lawrence, if you in a more formal matter, then you could maybe either speak to him or share that information via email or what have you.
Yes, sir.
Okay. All right. The status quo, I think that's fine as far as moving forward. I would like to set the matter over to July 31st. That will allow some time once the protection order is heard on the 22nd. That'll give Mr. Lawrence some needed time to speak to parties, do some investigation, and then provide feedback to the parties. So we'll set it to the July 31st. That is a Wednesday, and that'll be at 9 o'clock in the morning. And any concerns with that date, Mr. Jensen?
Sorry, I was spacing off. What was it?
That's okay. Any concerns with the July 31st date? Come back.
Sorry.
Okay, Mr. Lawrence?
No, the only aspect of that, Your Honor, is I've already been reimbursed for my services in the matter. I'd ask the court to consider giving me an additional about 5 hours.
That's fine. I'll authorize that verbally for an additional 5 hours.
Thank you.
Ms. Holder, any final items?
Your Honor, do you need us to put anything in writing that you can sign off on?
I don't think so. At this point, it was basically kind of a status check-in, and we've moved it to the 31st.
Thank you, Your Honor.
Great. Thank you.
Thank you, sir.
Thank you, Your Honor.
There we have Ms. Schaefer patiently there. Thank you. And Ms. Summer Norris, are you present? And Bradley Evans, are you present? Okay. Earlier, correct me if I'm wrong, Mr. Evans was not present and Ms. Norris was earlier.
Correct.
Okay. Have you had any communication with Ms. Norris in the interim?
Since then, no.
No. Okay. And I think what I said earlier, that we're just going to give Mr. Evans just a little more time just in case.
Yeah, I think Ms. Norris had stated she was going to try to reach out to Mr. Evans, and then I think we lost Ms. Norris in the effort.
Yeah. And then I see Miss Cheryl. Can you tell me your involvement in the case?
Hey there. Thank you, Your Honor. I was the child caregiver for the first 3.5 years of her life. And so I'm really concerned for her.
Right. So there's, the recommendations I think echo the concerns that are out there in part related to clean UAs and transportation and driver's license and insurance and hair follicle tests and the like. It's a situation that's fraught with a lot of potential dangers. So we were all gathered here today to get in to read the family investigators' reports and recommendations, which I have read, and I was hoping that the parties would be present. And without the parties being present, and with Ms. Norris being here previously, I'm not sure where she was going, because I think I said I would call 1 or 2 cases, but I exceeded that. But the idea was that I'd be calling it on today's docket. And I don't think that was easily misunderstood, that we were not going to be returning to it. I think there was an understanding that we would be returning to the matter today. So I guess, Ms. Schaefer, at this point, without both parties present, if I adopt your recommendations, that could be put into an order, and that would be required of the parties. And then I guess we could mail it to the parties and let them know what the status is. Do you have any input on that? Or
the only concern about mailing it to Mr. Evans is he's currently technically homeless, which is why I wasn't able to send his report via mail. So I don't know that I would be able to send it to the current location, because it's not 100% sure if he's still there at this time. I could do my best to reach out to both parties to let them know that I sent it again via email, and then confirm Ms. Norris's email that I have the correct one, and then verify with them that they have received the report and the updated order, or let them know to come to the courthouse and get a copy of the updated order.
Right. So just going back a little bit, on June 5th, both Mr. Evans and Ms. Norris were present, and we set it over to today, July 10th. So both parties were present on the prior hearing, and we're both aware of today's hearing now.
Yes.
So I'm fine then adopting the recommendations by the family court investigator, specifically that Ms. Norris comply with her treatment at the Kelso Treatment Center and be in compliance with that, and that mother's visitations could be, after 30 days of verified clean UAs, it could resume to be unsupervised. And after 60 days of verified clean UAs, then overnight visits could resume. And then the transportation, the father would have to have a valid driver's license and proof of insurance, and he'd have to show that to the court prior to transporting the child. And that Gracie Lee can and should be enrolled in Head Start for the fall session 2024. And that if Ms. Norris wants to ask father to take a hair follicle test, he would have to take that within 48 hours. And Ms. Schaefer, any reason not to make that bidirectional?
No reason why not to. It's just that she's currently participating in UAs as she is attending the Kelso Treatment Center. She unfortunately just hasn't had 30 days of clean UAs. And I would like to request, if possible, for dad to actually do that hair follicle test within 48 hours, as there are concerns that he may be using currently.
Meaning within 48 hours of today's date?
Yes, if possible. I just don't know if he'll be able to receive that notice within time to meet the 48-hour requirement.
Okay. Yeah, I'll authorize that within 48 hours of today, and or receipt. And then that Ms. Norris can request a hair follicle test in the future also.
Okay, great. Thank you.
May I ask a question?
You may.
What happens if both tests come back that they're using to Gracie? That my concern is she's in a household with everybody. She's in a flop house, and if they're still there and haven't run, and she's surrounded by people who are using and seeing domestic violence in the process, and how can I help keep her safe? I've called CPS. I don't know what else to do.
Yeah, it's a good question. It is a troubling situation. The safety of that young girl is clearly on the line. Anytime that there's any party has a concern for the well-being of a child, generally there's options of contacting law enforcement. There's options of contacting CPS, Child Protective Services. There's an option of a minor guardianship. Those are the three options that come to my mind.
I have done all three of those. And we're still in the situation, and she's still not safe. CPS says they don't get involved in court matters. So it doesn't matter if there's a court order of any kind, they won't get involved in that.
They will get involved if there's a report of a child being mistreated or being abused or in danger. There's not a prohibition that they say if there's a court action, then we're not going to get involved. I've never heard that before.
And when I call, they go and check her, even in a flop house with people using with no running water, and they're okay with her being there.
So those are the options that I'm aware of. I recognize that those options may be limited. I recognize that, if there's been a minor guardianship attempt in the past, sometimes things change, factors change, situations develop, and that may be a viable option, but I'm not sure. So there's really not a lot of great solutions right now, and I think she's clearly at risk. So with the adoption of those recommendations, let's see. Ms. Schaefer, are you in a position to draft an order that adopts your recommendations?
I could put myself in a position to be able to do so.
Okay, that would be appreciated if you could, and then I could, once I receive it, then I could sign off on that, and then it could be filed, and then it would be appreciated if you could share that with the parties.
Okay, I can do that.
Yeah, and Michelle, I apologize. You having been involved a lot and having a clear vested interest in the well-being of that little girl, it's got to be pretty maddening to not to be able to do more. And I just don't know. Those are the options that I know of, and I'm limited otherwise.
I understand, Your Honor, and I appreciate you letting me speak. I am prepared if Gracie needs a safe place. CPS knows I'm always available, so I'm prepared for that.
Okay. Great. All right. With that, that'll conclude at least today's hearing. Thank you. On the line, Anthony Cox.
Thank you, Your Honor.
Next, all right, Mr. Cox, if you're on the line, if you'll make sure that you're unmuted and state your name, Anthony Cox. All right, not hearing a response. And then Destiny Peters Ritzenthaler, if you're on the line, please state your name. Not hearing a response there. I'm looking at the participant list in the Zoom call. I'm not seeing names that would be, there's a Sarah Cox that's on the line. I'm not sure if maybe Anthony Cox is borrowing a phone there. Anthony Cox, are you on the line? All right, so we were here previously on June 26th at that hearing. Ms. Peters-Ritzenthaler asked for additional time to file her response. We set it over to today. She's filed nothing at this point. And there was, let's see, there was a proposed parenting plan with some limitations, 191 limitations on the mother, and also a restriction from exposing the child to a Mr. Ruff, and a request for a 50-50 parenting plan. But without either of them here, I'm not sure what to do other than on the 26th of June. Let me just verify who was present on that time. Looks like both were present and they both were aware that it was set over to today. I'm going to strike the hearing today. Neither party is present.
Yes, sir, I am.
All right. Thanks for your patience today, Mr. Phelps. I'll ask if Emily Dietrich is on the line. Emily Dietrich, are you here? All right, not hearing a response for her, no movement in the courtroom, and just double checking the Zoom participant list for an Emily Dietrich, and anything that's might be similar or related. Okay, not seeing anything that's related or on point. So let me just touch base. So Mr. Phelps, I reviewed your motion related to the genetic testing and the summary judgment for parentage. The one item that I noticed that, when we were here before, we talked about the affidavit of service, and it looks like you submitted an amended affidavit of service that listed out the precise or the specific names of the documents that were served upon Ms. Dietrich. So and I appreciate that. Then looking at that proof of service, it says that Brian Sullivan on the 27th of April served all those documents to Ms. Dietrich, and then he signed it on April 2nd. So there's an issue there in that he says that on the 27th of April, I served this person, Miss Emily, but I say that he signed it that on April 2nd. So he predated the signing or predated the delivery of those documents. So go ahead.
That's the date you delivered those documents.
And the 2nd or the 27th?
The 27th, the original in April is when he served her.
Right. I see that. But then he says he declares under penalty of perjury that all that's true. And then he signed this document that he's saying all that's true on April 2nd, which predates the service of the documents on April 27th.
Okay. Yeah, I'm confused because you said I didn't have to serve her those papers again.
You don't?
And the date he served her and then the date he signed the new one, the amendment, is the 2nd, correct?
Well, he signed it on April 2nd. So on April 2nd, he says he's looking prospectively, saying it's now April 2nd, and I served Ms. Emily on April 27th, which is an impossibility.
Okay, then we messed up signing that with the amendment part of it.
I think so. It's what we call often what we call a Scrivener's error, but it needs to be corrected before we can move forward. And I don't mean to be difficult with you, Mr. Phelps, is that I think your motion is very straightforward. The DNA testing is supportive of your position. It's just that service issue is a real key point, and it's a stickler, especially when you're talking about parentage cases and parenting plans, is that those are easy things for courts of appeal to reverse because of inadequate service. And if we get it right the first time, then there's no worry for an overturning of an order later on.
Okay, so we need the date that he originally served her the papers, correct?
Yeah, everything with the amended order, the amended declaration of service that was signed by Mr. Sullivan, everything's good except when he signed it. He signed it on April 2nd, which is an impossibility because he said he served her on April 27th.
Okay, so even though he's re-signing and amending it, he needs to sign the same date as the original one, correct?
What happens with this would be what we call a second amended declaration. You just need to be similar. He would need to state everything that he served upon Miss Emily, the date that he served to Miss Emily, and then he would be declaring that on the date that he signs it. So that would probably be in the next, day or two, I would assume.
Okay.
So what we can do, you were very timely in getting this amended declaration in. I'll assume you'll be timely in getting the second amended declaration in. So yeah, we could set it over 1 week if you'd like to the 17th of July. If you think you can get that second amended declaration in before then.
As far as work would go, I would need another 2 weeks. If that's
2 weeks. Yeah, that's fine. That's fine. So that 2 weeks from today would be the 24th. Would that work out okay?
Yeah.
Okay. Well, let's set it for July 24th at 9 o'clock in the morning for that second amended declaration of service to be filed. And Do make sure it gets in at least 5 days before that cutoff, so we have it in the file, and then we can address your motion on that date.
Okay.
Okay.
All right.
Any questions, Mr. Phelps?
No.
Okay. I appreciate your patience. And both parties are present. Shannon Wackob and Trina Wackob. Wackob, or we'll call
Wackob.
Wa. So it's a longer Wa.
Yeah.
Wackob. Wackob. Okay, Wackob. Thank you. We're here on Mr. Shannon Wackob's motion for temporary orders. Ms. Trina Wackob is present. What I wanted to touch base with you, and I wish I would have done this earlier, is related to service of documents. And I usually try to do this at the beginning, and I missed it. But I didn't see a return of service that Mr. Wackob, one of his representatives, had served Ms. Wackob with the pleadings for today.
Yeah, in fact, I'd gone through the sheriff's department, and after exhausting all other options and them failing, and actually she had to actually go physically and pick them up from the sheriff's office yesterday, because even though I had provided where she would be and when, they did not get them to her yet. So
okay. So she got him. You got him yesterday.
yeah,
Okay.
we've been in pretty good contact over what we were working on and things.
So as far as moving forward with a hearing today, I've read what Mr. Wackob wants and what his perspective is. I don't know what your perspective is. And as a general rule, my practice is to read what both parties are saying, sit with it, absorb it, contemplate it, think about it, make a decision, come here, and then listen to both parties share their respective positions again, and then see if my initial decision was right. And if it is, I'll go with it. If it's wrong, then I'll amend it or adjust it. So we probably need a set over to allow Ms. Wackob an opportunity to submit her response, and then come back and address the issues, because there may be some agreement that you may agree on some things, you may not. That's always the hope, but there's no requirement obviously for that.
Is there a way, and sorry to interrupt,
Yeah,
Your
no,
Honor,
it's fine.
is there a way to maybe quickly discuss something, because we are wanting to move forward on some overnights with mom, and expanding the visits and help kind of covering, childcare and schedule. We just really needed to kind of work this out. And my whole point of bringing this temporary order is so that we could have that brought in front of someone and hopefully made that agreement, so that there's no attempts to either keep the children or take them somewhere or me keep, you know what I mean?
Right.
So I just wanted to establish that I am open to and wanting to move forward on those overnights with mom, just that we still agree that they are living with me primarily currently. So is the point of today.
Okay. Is that kind of your understanding, Ms. Wackob?
Yes.
Okay. If, as a general rule, parties are free to agree to whatever they feel is going to be in the best interest of the children, and it's encouraged. I think you all are very much closer to the situation, have a lot more knowledge, a lot more history of what has happened or needs to happen regarding the children. So if you want to agree to something you can put it on the record. It's just kind of, it's an informal agreement.
Right.
It doesn't have the force of weight of a court order. It's just, it's been recorded. The party said that was what they're going to follow. And then we would come back here at a later date to discuss more in depth of what you've been able to work out and what you haven't been able to work out.
Correct.
Okay. So with, we're looking at maybe a 2-week time period to set this over. So Ms. Wackob, you would, if you wanted to submit something in writing, you would submit it to the court and you'd send a copy to Mr. Wackob for his review. And that needs to be done probably, 5 days before the hearing at a minimum. And then we would be here on I'm proposing the 24th of July, which is at 9 o'clock in the morning for that hearing. And so we get to hear from both parties. How does that work for both of you?
Yes, it should be okay. What is the criteria for being able to be available via Zoom versus in courtroom?
Your choice. If
Okay.
you want to come here, be in person, feel free. If you want to participate via Zoom, feel free. Yeah, no
Thank you so
requirement either way. Yeah. Ms. Wackob, do you have any questions?
I don't think so. Just we can start doing visitation overnight now. You're agreeing, right?
Yep.
Okay. No,
As arranged between us, yes, with availability, yeah.
Right.
Informal.
Yeah, right. So we will we'll look forward to hearing from your perspective, and then I'll review both perspectives newly, and then we'll be here on the 24th of July, 9 o'clock to decide.
Thank
All
you.
right, great. Thanks for your patience. All right, that concludes all the matters that were docketed on in front of the court, and so I'll go ahead and end the court call at this time and the Zoom call. Thanks.